Good morning, ladies and gentlemen, and welcome to this 25th anniversary of the Legal Aid Clinic of the Law Development Centre. Can I invite you all to please take your seats as we welcome our guests this morning. Ladies and gentlemen, please stand and we welcome our guests this morning. As we welcome our chief guest, representing the Chief Justice of the Republic of Uganda. Our chief guest this morning, the acting principal judge representing the Chief Justice of the Republic of Uganda, the Honorable the Attorney General, the Chair of the LDC Management Board, the Director, Law Development Centre, the Chair of the Law Development Centre Legal Aid Clinic Management Board, representatives of justice institutions present, ladies and gentlemen, good morning. As we start, I want to take the honor to invite our chief guest, the Honorable Lady Justice Jane Kajuga, representing the Chief Justice, the Honorable the Attorney General, the Chairperson and the Director LDC to please come and take your seats here as we start off the morning. I'll ask that we remain standing for the anthems. I'll invite the manager, Legal Aid Clinic, to come and lead us in a word of prayer.
Thank you, Ms. Odoi. Let's humble ourselves for the word of prayer. Heavenly Father, we give you thanks for yet another day, and specifically, we thank you for the Silver Jubilee celebrations of the Legal Aid Clinic. We thank you for our journey of 25 years. We thank you for having provided for the Legal Aid Clinic for the last 25 years. As we start these celebrations, Father God, we commit the function into your mighty hands. In Jesus' mighty name, I've prayed. Amen.
Please take your seats. My Lord, the acting principal judge, Lady Justice Jane Okua-Kajuga, representing the Chief Justice this morning, the Honorable Chiriowa Chiwanuka, the Learned Attorney General, the Chair of the Management Committee of the Law Development Centre, the Honorable Justice Christopher Izama Madrama, my Lord, the Chair of the Law Development Centre Legal Aid Clinic Management Board, Lady Justice Eva Luswata Kauma, the Director, Law Development Centre, the Acting Chief Registrar, the representative of the Director of Public Prosecutions, the Deputy Director of Public Prosecutions, Mr. John Baptist Asimwe, the representative of the Inspector General of Police present, the representative of the Commissioner General of Prisons, representatives of different institutions and academia, colleagues from civil society and legal aid service partners, invited guests, ladies and gentlemen. A good morning to you all. My name is Rachel Odoi Musoke. I will be taking you through the program this morning as we celebrate the Silver Jubilee of the Legal Aid Clinic of the Law Development Centre. We are gathered here to commemorate 25 years of clinical legal education and legal aid service provision by the Law Development Centre under the theme, 25 years of advancing access to justice through legal aid and clinical legal education. And indeed, today is a celebration of service to the most vulnerable members of society. So we welcome you all here, and we are very honored to receive you to celebrate with us on this Silver Jubilee. My Lord and honorable guests, we take this opportunity to welcome you, but the words of those who are the hosts this morning will be the words that will officially welcome you. And with that, allow me to call the President of the Law Development Centre Guild, Mr. Ayebare Vianney, to give you his official welcome.
Permit me stand on the protocol that has been laid by Ms. Odoi. Good morning, ladies and gentlemen. My name is John Vianney Ayebare, and I'm the Guild President at the Law Development Centre, Kampala. Permit me to welcome you to this very wonderful celebration of 25 years of LDC Legal Aid Clinic. Indeed, today's theme, 25 years of advancing access to justice through legal aid and clinical legal education, is a reminder not only to the clinic's work in provision of legal aid services to the indigent and accused persons, but also the excellent contribution in training and sharpening back-course students through clinical legal education. On that premise, ladies and gentlemen, on behalf of the students community, we would like to extend our immense appreciation to all stakeholders who contributed and those who continue to contribute to the establishment, management, and sustenance of the clinic. We are very grateful. Your efforts are felt on a daily basis. When we, the students, get to practice what we are taught in theory and we practice it practically, your efforts are recognized. When we, the students, under supervision, assist an accused person and a victim to have justice delivered timely through alternative dispute mechanisms, your efforts are felt. When we interact with practitioners for mentorship, guidance, and training, your efforts are felt. And for all this, once again, the student community is profoundly grateful. As we look back to how much has been achieved in the last 25 years, we should also be reminded of the journey ahead. We must look at the future as one where we are challenged to continue to build a society that evolves and adapts to technology, demography, the environment, and culture in order to maximize the gains achieved in the last 25 years. I should tell you not to worry about such a future. That future is secure. It is secured because the members of the Guild Cabinet, some of whom are here and others are there in attendance, have committed to carry forward the lessons learned here through clinical legal education. The students themselves, and some of them are here in attendance, have committed to carry forward the lessons learned through clinical legal education. And I myself am committed to that. And therefore, finally, I'll pose a question to all of us. What is your commitment in ensuring that the legal aid clinic achieves its objectives of providing legal aid services to the indigent and training back-course students in the next 25 years? I thank you for listening to me, and congratulations to the Legal Aid Clinic upon completing this milestone for God and my country.
My Lord and honorable members, the Legal Aid Clinic is a student-based clinic, and the leadership here represent those students who provide legal aid services as part of their legal education. It's now my honor and privilege to invite the Director, Law Development Centre, Dr. Pamela Tibihikira Kalyejira, to formally welcome us this morning. You're welcome.
My Lord, the Honorable Chief Justice, represented by the Acting PJ, the Honorable the Attorney General, my Lords and Lady Justices, members of the LDC Management Committee, development partners, leaders of the bar and legal aid service providers, teaching faculties, the Guild leadership at LDC Kampala, our students, distinguished guests, ladies and gentlemen, a very good morning to you all. You are most welcome to LDC. It is such a pleasure to see so many of you who are our alumni and we're always looking to recruit you to come and give back, to teach. And so I'm seeing some people in the room who have not yet been to speak to our students. And so I'll be keenly following up to have you there. It's very good to see some oldies as well, since I'm now in that bracket. Today we celebrate 25 years of the Legal Aid Clinic, a homegrown innovation that has linked learning to service and brought justice within reach for the indigent and vulnerable, while molding future advocates equipped for practice. What does LAC add to LDC? LAC holds deep significance not only for the justice institution represented here and the indigent persons we serve, but also for us as an institution for the reasons I'll outline below. LAC is our corporate social responsibility in action. It is our institutional way of standing with citizens who would otherwise face the system alone. The clinic is LDC's enduring commitment to give back by offering free legal services, taking legal information, counseling, alternative dispute resolution mechanisms to prisons, police, remand homes, and communities. LAC is a living classroom. Through clinical legal education, the learning court, and supervised student practice, LAC turns doctrine into competence, ethics, and public service ethos. Our graduates have not only learned, they're ready to serve. In a special way, I'd like to recognize the head of the LDC court. His worship, Timothy Lumunia, is seated there with his team. They have been very instrumental because it's just walking distance for our students. And of course, Timothy and his team were all my students at UCU, and I'm very proud of you. You're doing a very good job. Gender and equity compliance. The clinic's eligibility tools, stroke client profile, disability accommodations, and data desegregation make LDC's mission measurable, inclusive, and fair, as per the requirement of the Public Finance and Management Act, laws of Uganda. We have put equity at the core of how we teach and serve. As we celebrate this day, I wish to express our heartfelt gratitude to our stakeholders and partners. I see some of you seated over there. Our willingness to welcome our clinical legal education students, your willingness to welcome our clinical legal education students into your institutions has enriched our education approach, providing invaluable practical experience that complements and enhances our teaching role. Special thanks go to the judiciary, the respective High Court divisions, High Court circuits, and magistrate areas, Office of the Director of Public Prosecutions, Uganda Police Force, Uganda Prison Service, the Public Procurement and Disposal of Assets Tribunal, commercial banks, Uganda Registration Service Bureau, Ministry of Lands, Housing and Urban Development, especially the ministerial zonal offices, Bank of Uganda, Ministry of Gender, Labor and Social Development for the remand homes and industrial court, Insurance Regulatory Authority, Insurance Appeals Tribunal, and the various legal aid service providers. You have all warmly welcomed our students, and we thank you ever so much. To the Government of Uganda and our development partners, thank you for the financial support which has enabled us to reach out and turn policy into service. To the local governments, thank you for the support offered in form of office space, referrals, radio talk show time, airtime, and opening up doors for our staff to deliver services without any disturbances. To our clinic staff, thank you. Thank you for extending the legal services with utmost professionalism, compassion, and dedication. In a very special way, Miss Lydia Namuli, I don't see her from here. Yes, Lydia is very instrumental in the clinic, and many of you have met her. She's the face of the clinic, and Lydia, thank you very much. I know you've worked flat out this week. To our clients, the users of LAC services, you're the reason we exist. The Honorable Attorney General and the Law Council, we implore you to protect and grow the LAC budget line tied to outputs that matter and ensure fast dispensation of justice, including early legal engagements, representation at first appearance, increased ADR settlements, diversion for juvenile offenders, and reducing the duration from when an issue, request, or incident is first reported until it's fully resolved. We implore you to facilitate timely prediction, inspections, and accreditation of legal aid service providers with feedback mechanisms designed to strengthen rather than disrupt service delivery. We also call upon you to champion Duty Council standard operating procedures in collaboration with the Office of the Director of Public Prosecutions, the Uganda Police Force, and the Uganda Law Society for easy police access and fast appearance targeting, a practical 12-hour response time from custody notification to legal contact. To the judiciary, keep courts open for learning sessions and court annex ADR, and help us align timetables so student practice complements rather than competes with trial scheduling. And also for you to use shared indicators to improve case management and reduce on adjournments when counsel access and disclosure are veiled in a given case. To the local governments and the justice sector MDAs, we implore you to maintain office space for clinics, enhance referral services and support in legal outreach coordination, and work alongside us on public legal education involving providing free radio talk show airtime on local stations. I must say most of the RDCs have very willingly given us some of their airtime so that citizens know what to do and who to engage before a problem becomes a crisis. To the members of the bar, Uganda Law Society, and our alumni, join our micro-panel strategy, one student supervised case per quarter, periodic mentorship in drafting, ethics, and ADR. Many hands make the work lighter and will be better equipped lawyers. To our development partners, I'm not seeing Dr. Katya Katumbar, maybe she'll come later. I saw I think Ms. Nyambe as well. We thank you for your support, and we hope it will always be aligned with government planning frameworks to maximize its impact. What lies ahead? At 25 years, and I'm concluding, the Legal Aid Clinic has evolved from a project into a benchmark for practical and ethical legal education. It stands as a testament to the belief that public institutions must serve the community. Our commitment is to the effect that every eligible individual deserves timely access to legal counsel, and every graduate should gain experience through service. We thank everyone who has supported us on this 25-year journey. May this Silver Jubilee strengthen our collective determination to make justice acceptable to all. As I conclude, I once again welcome you to LDC. Enjoy the celebrations for God and my country.
It was the Director, Law Development Centre, Dr. Pamela Tirihikira Kalyejira. Chair and Honorable Attorney General, the people who provide legal aid here are part of the foot soldiers, the team of the Attorney General. They go out and they represent clients, the most indigent, including and in particular children, and providing legal aid services so that they are able to be properly represented in court. So these are part of the team that we have as legal practitioners within the Ugandan system. With this, I want to take the honor and the opportunity to invite the learned Attorney General, the Honorable Chiriowa Chiwanuka, to address the gathering. You're most welcome.
The Honorable, the Chief Justice, represented here by the Acting Principal Judge, Lady Justice Jane Okoh, the Honorable Justice Christopher Madrama, Chairperson of the Management Committee of Law Development Centre, the Chairperson, Legal Aid Clinic Board, Honorable Lady Justice Eva Luswata, Justices of the Court present, Judges present, Your Worships present, representative of the IGP and the Commissioner General of Prisons present, members of the Management Committee of the Law Development Centre, the Director, Law Development Centre, our partners in the Justice, Law and Order sector, Ms. Lydia Namuli, the head of the Legal Aid Clinic, distinguished members of the Bar and Legal Aid Service providers, the Bar students, our foot soldiers, and the front line of legal aid, ladies and gentlemen in your various capacities, I greet you all in the name of the Lord. Before I start on my remarks, when Miss Namuli came up to lead us in a word of prayer. She said, let us humble ourselves in prayer. Originally, they used to say, let us close our eyes. I don't know why you don't want to close your eyes anymore in public. Is there something you're worried about here? It's just something that came to me and I said, but so I closed my eyes, then I opened one and I realized no one had closed it. So I also opened both eyes. But returning to LDC is always nostalgic. It's always an interesting place. LDC brings back some really fond memories. It is one of those bittersweet memories. You look at the buildings, you look at the place, and you remember, was I suffering, was I enjoying? So I was reminiscing with my partner in Farm D, Lady Justice Jen Okuo, because she was my moot partner. And I was saying, this place here is a bit different. And I can see some of our classmates are here. But today we are here to celebrate 25 years of the Legal Aid Clinic. This is 25 years of advancing access to justice through the Legal Aid Clinic and the continuing legal education. This initiative has shaped the careers and lives of many legal practitioners that have gone through LDC, in particular the Legal Aid Clinic, and has impacted many lives. Legal Aid Clinic was founded in 1998 and started its activities in 1999. The vision was simple: to link the service to learning and strengthen Uganda's access to the justice system. I must say I personally missed participating in the activities of the Legal Aid Clinic since the clinic was launched a year or so after I had graduated from the center. As I stand before you, and as we reflect on the achievements of the past 25 years, I cannot help but wonder how my cohort and others before us, particularly those whose favorite part of practice is taxing bills of costs and a hefty retainer, would have turned out had we gone through this impactive program. So maybe I would have written my bills a bit differently, having gone through this. So I don't know how it would have turned out. The clinic derives its mandate from Section 3.1 of the Law Development Centre Act, Cap 251. In fulfillment of its mandate, the clinic is implementing a number of projects that include supporting juveniles and petty offenders to access justice, running a reconciliation program at a number of magistrates' courts, and offering legal aid to indigent litigants and accused persons, among others. The Legal Aid Clinic was established with a mission to enhance access to justice through the provision of legal aid to indigent and accused persons, while building skills of upcoming lawyers under the CLE program, linking service to learning and strengthening Uganda's access to the justice ecosystem. Therefore, legal aid is a bridge for justice for millions. Today we celebrate the Legal Aid Clinic, which makes it accessible. Legal aid is not just a service, it is actually a symbol of hope. Over the years, the clinic has done more than any of us could have imagined. From a single office at the LDC in Kampala, it has expanded to satellite clinics across the country in Kabarole, Masindi, Adjumani, Jinja, and later to regional LDC campuses in Mbarara, Lira, and Mbale, bringing legal services closer to communities that need them most, and supporting the functionality of the criminal justice system through prison decongestion and case backlog clearance. The Legal Aid Clinic has moved from a one-man staffing to a staffing of 45. Congratulations to you all. Presently, from the information we have, over at least 10,000 indigents have received assistance through the legal awareness, legal counseling, and representation. This has facilitated decongestion of prisons and contributed to case backlog clearance. Hundreds of students have gained practical training through CLE program. Buttressed by Advocates Student Practice Regulations of 2004 and the establishment of the Learning Court at LDC, shaping both their skills as legal practitioners and their sense of professional duty. This was actually really insightful for the people who came up with this idea, because for us, our courts were You had to organize a judge from among yourselves. Then you organize the lawyers, organize the witnesses from among yourselves. Everything was from among yourselves. But whoever came up with this idea must be saluted. We salute you. The Hard to Reach Students Program, which allows communities and accused persons to access legal services, is a reminder to students that legal practice is not merely a means to make money, as many often perceive it, but a tool for justice and service to disadvantaged members of the community. The Advocates Legal Aid to Indigent Persons Regulations 2007 operationalizes and provides a benchmark for the provision of legal aid services. This journey of providing legal aid has not been without challenges. Of course, limited resources and high demand for the clinic services have often strained the already dwindling resources. I do, however, commend the clinic and its leadership for the work that it has done despite these challenges to turn ideals into action through its various pro bono services, such as reconciliation, plea bargaining, and diversion programs for juvenile offenders. In providing these services, the clinic has shown that access to justice is not just a promise, but a living reality. It has breathed life into Article 28 of our Constitution, by ensuring that those who cannot afford to pay for the services of a lawyer, particularly the juvenile and indigent, receive legal representation. In so doing, upholding the right to a fair hearing and safeguarding access to justice. Actually, what this legal aid clinic has done, it has expanded the frontiers of Article 28, because Article 28 provided for services to be given to a certain class of persons. But the legal aid clinic has expanded these boundaries, and we salute you for that. I applaud the clinic for effectively partnering with various government institutions, as the director has already enumerated, but more importantly, including the Ministry of Justice, which is our mother ministry, and the judiciary to fulfill its mandate. I'm also alive to the fact that there is a pending matter of a private member's bill on legal aid. Although government of Uganda is committed to having more legal aid clinics to enhance access to justice through the provision of legal aid to indigent persons and accused persons, we need to address its financial sustainability. We, as government, support the concept and the ideals of legal aid. Let's work together to find a middle and agreeable point as we grow this area. A sustainable legal aid system, of course, needs government support, and you have our support. I can confirm that. It requires extensive community engagement and, of course, innovative approaches like you have already done to access to justice, such as the use of ADR, technology, and many others that you have mentioned. I can commit to you, my Lord, the Honorable the Chief Justice and members of the Management Committee, that you have government's full commitment to supporting legal aid in Uganda. Looking ahead, our collective focus should be on strengthening what works. This works. This program, as we have it here, works. Let's work to strengthen that. We must continue to advocate for increased funding, and we shall continue to do that. And in our meeting with the legal aid leadership, I did mention that. We must endeavor to greater use of technology, among others. We must remain committed to providing early access to counsel and supporting the clinic to reach the most remote areas. I recognize that every Ugandan deserves timely, quality legal support, and every aspiring advocate deserves the chance to learn by serving. I applaud again the Legal Aid Clinic for providing this opportunity. Personally, I will continue to support the Legal Aid Clinic of the Law Development Centre in carrying out its mandate by giving it policy direction and assisting in mobilizing resources through the Ministry of Finance, Planning and Economic Development to enable it to carry out its mandate. Of course, we thank our development partners who continue to support us here, but this primary mandate lies on government, and we commit to continue doing our best in that space. Legal aid paves the way for justice. On this day, let's salute those who provide essential services to protect our rights and dignities. For the students, BACO students, we salute you. To the leadership of Law Development Centre, the leadership and staff of the Legal Aid Clinic, and students, thank you for your dedication. Thank you again. You have shown that justice can be both compassionate and effective. Let us continue to carry this vision forward, together with ensuring wherever there is need, the hand of justice is not out of reach. Before I close, the Honorable Chief Justice, honorable members present, all of you in your various capacities, I must apologize, which is not my way of doing things, that I may be required to leave a little earlier than I would have been expected. In fact, I may leave before the chief guest leaves her seat. I sincerely apologize for that, but I have some other commitments which I must undertake. I thank you all for your attention, and I say all this for God and my country. Thank you very much.
We thank the Honorable Attorney General for those remarks and for the commitment of government towards the support of legal aid. And we look forward to working together to make the legal aid system for Uganda a robust and effective system. Allow me to take this opportunity to recognize some of our guests here today. As we've already been introduced, our chief guest here today, representing the Chief Justice, is the Honorable Lady Justice Jane Okuwa-Kajuga, the Acting Principal Judge. My Lord, you're most welcome. We also have with us the Learned Attorney General, the Honorable Chiriowa Chiwanuka. You're most welcome. We also have with us the Honorable Justice Christopher Madrama Izama, Justice of the Supreme Court and Chairman of the Management Committee of the Law Development Centre. My Lord, you're most welcome. We have with us also the Honorable Lady Justice Eva Luswata Kauma, Justice of the Court of Appeal and Chair of the Law Development Centre Legal Aid Clinic Management Committee. We also have with us the Honorable Justice Wolimbwa Paul Gadenya from the High Court. My Lord, you're most welcome. We have with us the Acting Chief Registrar, Her Worship Pamela Lamuno. Your Worship, you're most welcome. We also have with us the Deputy Director of Public Prosecutions, Mr. John Baptist Asimwe. We have the representative of the Commissioner General of Prisons, Assistant Commissioner General of Prisons, Mr. Milton Tio. You're most welcome. We have the representative of the Inspector General of Police, Assistant Commissioner Dina Chasimire. You're most welcome. We have our colleagues, their worships from the judiciary. I'll welcome Mr. James Eremie, his worship, Mr. James Eremie. We have with us Ms. Prosi Katushabe, her worship, the Registrar High Court. We have his worship, John Paul Edoku, Registrar Planning. We have her worship, Tusime Sarah Barunji, the Registrar in Charge Family Division. We have in our presence also colleagues from other institutions. I want to welcome Ms. Irene Lugaizi from the Ministry of Justice and Constitutional Affairs. You're most welcome. We also have Ms. Margaret Nabakoza, the Secretary Law Council. You're most welcome. We have other honored guests who are present here with us. Allow me to welcome also Her Worship, Ms. Esther Nahiria, Senior Principal Magistrate in Charge, Matuga Court. Your Worship, you're most welcome. We have Mr. Simon Peter Opolot from the Registry of Planning in the Judiciary. We have Ms. Sylvia Nambiru Mukasa, the Chief Executive Officer, Legal Aid Service Providers Network. We have Ms. Lilian Adriko Biarugawa, the Chief Executive Officer, FIDA Uganda. We have colleagues who are former members of the management committee. We have Dr. Anthony Kakoza. We also have former staff and members of the Legal Aid Clinic. We have with us Dr. Donald Rukare. We have colleagues representing other partner institutions. We have Ms. Jane Langwea Okotpitek representing the Institute of Corporate Governance. And I'll continue to recognize other members as they arrive. Allow me now to invite the chair of the Law Development Centre Legal Aid Clinic Management Committee to come and give us a brief overview and a history of the journey of the Legal Aid Clinic over the last 25 years. Please welcome the Honourable Lady Justice Eva Buswata Kauma, Chairperson, Legal Aid Clinic Management Committee.
Thank you very much, Ms. Odoi. Good morning, everyone. My Lord, the acting principal judge representing the Chief Justice. Allow me to stand on the protocol that has been established. I've been given only 10 minutes, and I must make an apology. I'm going to overstep the 10 minutes because I feel what I have to say is what LAC wants you to know, and it may be a little more detailed. So it is a privilege to hold the Silver Jubilee celebrations of the Legal Aid Clinic of the Law Development Centre when I'm the serving chairperson, and allow me briefly to lay out the history of the clinic by first introducing, to let you know, some of the chairpersons emeritus in whose footsteps I'm walking today. So our first chairperson was Lady Justice Solome Balungi Bosa. Those who practiced law back then know her very well. She was our first chair. She now sits at the ICC. She was succeeded by His Lordship, Justice Frederick Egonantende, who is at the Court of Appeal. He then handed the mantle to Lady Justice Stella Arach. She's now deceased, but was sitting at the Supreme Court. The immediate past chairperson is Lady Justice Catherine Bamgemerere. We had hoped she would be here, but probably due to commitments. So you can see these are very eminent persons of our profession. And actually, when she was introducing the people here who are connected to the clinic, I believe they are all eminent persons, and they hold it dear. Many thanks to my senior colleagues for a job well done in laying a strong foundation for the Legal Aid Clinic. Maybe before I start, I left my list there, that paper. Can I have it? The paper. We celebrate an entity of national value that has linked service to learning for 25 years, which is a long time. And notwithstanding and turning the legal representation on paper into remedies in people's lives. Lawyers, we are not taught lived realities of people. It is not part of our training. So we do our law in the abstract. And, seeing what the Attorney General said, we were not lucky enough to be part of the clinic. So some lawyers purpose now, the older generation, have to purpose to understand lived realities of people. And that is what legal aid does. You get empathy, you sit in the life of that person, not just to dispense justice, but to understand what they go through. And that is what we practice. The brief history of the institution has been given, and I will just give snapshots that I think the Attorney General didn't talk about. The clinic was set up in 1998 to fulfill a statutory mandate to assist indigent and accused person. And of course, we then also have CLE, which is clinical legal education. I won't go into the details of that. But in 2004, the Advocate Student Practice Regulations Statutory Instrument number 70 of 2004 came into force. It formalized supervised student appearances in magistrates' courts and anchored the clinic's pedagogy in real practice. And we go back to what I've said. In 2010, the court, the LDC Land Court, was launched, and the Attorney General has gone into the details of that. In 2011, the Judicature Reconciliation Rules, Statutory Instrument number 41 of 2011, was enacted. So the clinic is now able to deploy court-annexed reconciliators and mediators, bringing ADR into everyday case flow. And my lord, I'm happy to confirm that we have 17 court-annexed reconciliators and mediators. And the chief magistrates hosting this noble force are present today. They have been introduced. And I must mention that Justice Christopher Madrama, the current chairperson of the LDC Management Committee, spearheaded the research into the use of reconciliation as ADR mechanisms and actually came up with the first draft of the rules while working as a senior legal officer. If I may digress a bit, currently the judiciary is very concerned about ADR as a mechanism that assists us to reduce backlog. And the Chief Justice is actually championing this within the judiciary throughout the country. And LDC is, people don't realize, but LDC is one of the most important partners in this because they have this trajectory of juvenile justice. Not many legal aid service providers are doing this. FIDA may be doing it, but with the older women, you know. Everybody is working with older offenders, but we have the monopoly in there. And because the students are actually trained, the general faculty, and then those who actually do CLE, we target case flow with the use of ADR, which is very important. 2011 marked the roll out of the diversion program tailored for juvenile offenders. The program was marked with the diversion guidelines of 2011 and the onboarding of fit persons and social workers. I have, during my work, met with some of these people, the fit, they're very passionate. They are not lawyers, but you know how non-lawyers feel good to work with us, especially those in the communities. And by doing that, we are equipping them with skills to help us in areas that we cannot reach ourselves. Then, of course, we have our foot soldiers in the hard-to-reach places. It's amazing, my lord, when you visit these young lawyers to be and the advocates. They're working in very difficult conditions, but they're happy. They do it with a smile. And when we visit the magistrates, they are telling us the good work they are doing and asking us, please do not drop this project. We shall go under. And they're very serious about it. So, Attorney General, Senior Counsel, this is a very serious request. In all your considerations, look at LDC in a different way. We are giving a service you are not going to receive from any other service provider. 2012-2015 witnessed LAC expansion beyond Kampala to regional and satellite locations. We are in Kabarole, Masindi, Kagadi, Chibale, and Adjumani, expanding the service points to 6. Though we suffered a setback by the closure of Kagadi and Chibale when DGF pulled out, a huge boost was to be realized with the opening of LDC regional campuses, which gave back 3 fully fledged legal aid clinics. So that is in Mbale and Lira and Bara. Bring the number of approved chambers by the Law Council to 5. And the period marked strengthened governance with a multi-sector advisory board that we have today with representation from various government and civil service. And at that juncture, my lord, I had I am the chair of that advisory board, and we really give policy direction to the clinic. And I will just introduce the members of the Legal Aid Clinic Advisory Board quickly, and when I do, please, if you are here, you may stand up. My Lord, apologies, some were engaged elsewhere. So we have Dr. Pamela Tibihikira Kalejira, of course, the Director, Law Development Centre. We have Hawashi Prosi Katushabe, Registrar of the High Court. Margaret Nabakoza, our representative from the Law Council. Mr. Robert Mackay heads the Department of Postgraduate Studies and Legal Aid. He's not here today. Mr. Bulamu Mayanja, Head of Department, Law and Continuing Legal Education. Mr. Eric Hatanga, who has also chaired all these preparations, is our representative of the Legal Aid of Uganda Law Society. Ms. Carol Idembe Bunga represents legal aid service providers, and we have many here. Maybe you could stand up, please, for recognition. Legal aid service providers from... Yes, so, my Lord, we don't compete, we cooperate, and we support each other. Dr. Businje Kabumba is not here. He represents Makerere University, but he's represented by Dr. Richard Naluwairo. He's the Dean, Makerere University Law School. And of course, our Secretary, Lydia Namuli. You have seen her. We, as a board, we meet regularly to decide, like I said, on policy and other directions. In 2013, LDC has improved. You know, by 2013, we have improved LDC's academic finance and human resource and quality systems, ensuring sustainability and accountability of the clinic. And this period has been marked with the sector-wide approach, and the clinic partook of the justice, law, and order sector strategies, and special thanks goes to the JLO Secretariat that has offered a lot of support and direction. The docket has over the years broadened from criminal defense, which was our core practice area, to civil justice, land, family, labor, contract, tort, with ADR being the forefront footprint. And as it has deepened, diversion and social work has become the standard for child-sensitive justice. My Lord, it's inevitable. Once you work in legal aid, you may start off with one trajectory, and then you find the need. People are going to come to talk to you about their child, and then they will have so many other problems. So this has grown the clinic, and that means the students are getting an all-round education in actual practice. So progressive achievements and impact, of course, our access to justice. Each year, thousands of Ugandans, often in the numbers of 10,000 plus, receive legal information, counseling, and representation and NDR. Training that changes outcomes, and statutory instrument number 70, roughly 180 to 200 student practitioners annually draft, advise, and appear under supervision at the court or in clerkships, as I said, even in hard-to-reach districts. Up to 20 students support prisons decongestions and backlog reduction, and our colleagues from the prisons can testify to that. We have, of course, mainstreamed ADR. Over 2,000 cases are handled through court annexed reconciliation and mediation that operates at multiple stations, which I've mentioned, while over 1,500 juvenile offenders access legal services and diversion support across 8 districts. People, you must understand that children, we have barriers to justice, even an adult. So you can imagine the kind of barriers people under 18 face, because they don't have the money, they don't have even family support, and then all the other social and cultural barriers and that they will face. So we are doing a job that must be mentioned. The learning court is the signature method. Competency skills, supervision ratios, file reviews, and reflective practice produce graduates who are ready on day one to go. And we have grown partnership with government and NGOs, and as well as the Uganda Law Society. We have now institutional maturity in that the clinic is now fully integrated into LDC and has stabilized financing, professionalized staffing, and standardized quality assurance, and aligned the clinic with the national planning frameworks. And we've already discussed that with you, Attorney General. So we have grown from one manager with a handful of volunteers and back-office interns to 50 staff today, 17 full-time and 40 part-time employees. Our current model is student-delivered, supervisor-led, and keeps unit costs low while embedding ethics and skill. That should excite our government. We system-embedded court center and follow the court calendars, and we have help desks within the clinic, within the clinics around the country. We have duty counsel who are on spot. I was amazed when we went to, I think, Kabarore, and this magistrate was saying at any one time in the day, I'm able to call upon duty counsel and those that support him to help me with my work. We have ADR rosters and relieve case flow and reduce delay. So we have a whole person approach, which to me is what law should be. We work with social workers, fit person networks, deep down in the villages, and referral pathways to ensure trauma-informed, child-sensitive responses. So in a nutshell, Attorney General, I believe, as I have said, we have given all the good reason for the clinic to be maintained in whatever form legal aid education is going to take. We have some challenges, like most institutions do. Demand far outstrips capacity. Remember, we are only having students learning, so that is expected. We have problems of supervision ratios because the advocates have to go to mainstream courts, supervise the younger ones, and the manager is running the clinic. And of course, caseload pressure can threaten quality if not carefully managed. We have funding volatility. There is limited funding amidst many equally competing priorities. We still have technology and data gaps, needs for a secure case management system and real-time dashboards to drive decisions, budgeting, and accountability. We still have geographic and inclusion barriers. We need interpreters, disability access. You know, we are working for a poor community, language coverage, and the cost of reaching remote communities. And for this, I may tell you, my Lord, for the hard-reached, the local governments have been indispensable to assist us. They'll put their cars, the local government cars, the local government space, to ensure that our foot soldiers get to prison and also get to the remand homes. Regulatory timing, inspection and approvals, and this speaks to the Law Council, and approvals can lag when clustered with private legal aid service providers. As a recommendation, my Lord, I call upon the power that be to consider the following recommendations. We ask that, if possible, ring fence and grow the LAC budget line linked to measurable outputs. Secondly, policy formulation that speaks to first appearance coverage so that we are able, and this speaks to our colleagues in prisons, in police, the magistrates, all those people who are in the chain, in the justice, especially the criminal justice chain system. Give us some priority. I used to do that as a trial judge, if a legal service aid provider stood before me, I would understand the pressures they have to be even able to come to court. I would give them that leeway. And I ask my fellow judicial officers to do the same. And we, of course, would want some support in digital case so that we can manage our cases better using current, advanced technology. We hope to deepen our relationship with justice actors and local governments, and we ask them to support us that way to grow a micro panel of, and we hope we can grow a micro panel of alumni and members of the ULS so that we can at least have one case per council per quarter. And this speaks to our representative. You can carry this back, and it's achievable because I am aware that now in the Uganda Law Society you must give pro bono. And sometimes we forget the juveniles. I don't recall in my time as a member of the Law Society I ever did any work with juveniles. So with that, my Lord, I thank you very much for listening to me, and I salute the clinic for this great milestone. Thank you very much.
Thank you very much, my Lord, for that overview of the Legal Aid Clinic. Allow me to recognize a few more of our guests present here today. We have with us Professor Philip Francis Iya, former director of the Law Development Centre. We also have with us Dr. Ademeo Wale Latif, the Dean, Faculty of Law, Islamic University in Uganda. We have with us the representative of the Dean, Uganda Christian University, Mr. Andrew Nyombi. I think he's present here. Most welcome. We have with us the registrar of the PPDA Appeals Tribunal, Mr. Atiku Saki Mansour. We have the representative of the Registrar General, Uganda Registration Services Bureau, Ms. Namudu Jacqueline. We have His Worship Conrad Obol, the Magistrate Law Development Centre Court. We have Her Worship Doreen Ainembabazi, Magistrate Law Development Centre Court. We have Mr. Aduti Timothy, the Resident State Attorney at the Law Development Centre Court. We also have Ms. Victoria Nariema, the Legal Officer, Uganda Prison Service, representing the Commissioner Legal. We have Ms. Deborah Gassana from UNICEF. We have Ms. Annette Mpabulunji Wakabi from UNDP. We have the in charge of Mbale Remand Home, one of our key partners, Ms. Sarah Amunir. We also have with us the Reverend Father Dr. Charles Rwanga Makoboza, the Assistant Chaplain, St. Augustine Chaplaincy, Makerere University. We have the former manager, Law Development Centre Legal Aid Clinic, Ms. Theodora Bitature Webale. We have a representative of the Uganda Law Society, representative of the Chief Executive Officer, Uganda Law Society, Ms. Sheila Turia-Singura. We have partners from Virman Partner, the managing partner representing Virman Partners, Mr. Raymond Njangambaki. We also have with us staff of the Law Development Centre Clinic here. We'll just introduce a few of them. We have Ms. Kaija Imelda, the Manager Finance. Ms. Betty Logose, the Senior Internal Auditor. Mr. Senabulia Joel, the Manager Publishing. Mr. Humba Eric, the Acting Head of Department for Library, Mr. Felix Mukundane, the Senior Systems Administrator, Ms. Aber Harriet, the Senior Procurement and Disposal Officer. And we have with us one of our other guests who will be taking us through the panel discussion later. We have Professor Charles Mbazira. I think he's here, but he will be taking us through the panel discussion shortly. Christopher, sorry, I have it here as Christopher. My apologies, Professor. The Honorable Chief Justice, our chief guest today. We've had the history of the Law Development Centre. We've had the introductions from the director. We now welcome a keynote address, which is going to address our theme this morning, 25 years of empowering student learning through clinical legal education and championing corporate social responsibility. And our keynote speaker this morning is the chairperson of the Law Development Centre Management Committee and the Justice of the Supreme Court, His Lordship Justice Christopher Madrama Izama. My Lord, you're most welcome.
Okay. Good morning. Yes, my Lord, the Honorable Chief Justice, in your representative capacity, your Lordships, honorable guests, colleagues, friends from the academia and the legal aid fraternity, I adopt the protocol as laid to conserve time. And it gives me great pleasure to stand here before you as a privileged person who is associated with the Law Development Centre Legal Aid Clinic from end of 1999 and the year 2000. I am also privileged to see Theo Bitature, who was my manager that time. I can see Don Rukare, with whom my colleague in ABS. So without much further ado, I would like to launch to my address. The gathering today marks a profound institutional milestone, the Silver Jubilee of the Law Development Centre Legal Aid Clinic. This commemoration is not merely a reflection on the passage of time. It is an obligation to demonstrate through clear and detailed evidence the systemic impact of the clinic's operational model over the past quarter century. The institution celebrates 25 years of steadfast commitment to two interconnected pillars, delivering practical world-class legal education and ensuring public access to justice, thereby upholding the constitutional promise of access. The core strength of the clinic lies in its synergistic mandate. The clinic was established precisely to fulfill a dual role: to deliver free legal services to indigent, vulnerable, marginalized persons, including women, children, and persons with disabilities, while simultaneously acting as the mandatory practice-focused arm of the bar course through the Clinical Legal Education, CLE. This integrated model yields exceptional results. It consistently produces ethical, practice-ready lawyers while simultaneously delivering high-volume, cost-effective services to the public. Crucially, clinical legal education is not simply an added curriculum component. It is the fundamental economic engine that sustains high-volume social responsibility. This methodology fundamentally changes the relationship between legal training and public service, creating a system where the pedagogical mission, and while I was using this term, which I learned from LAC, I thought maybe we had other persons where pedagogy just means methods and practice of teaching. So the pedagogical mission inherently subsidizes the cost of large-scale legal service delivery. To fully appreciate the championing of corporate social responsibility demonstrated by the clinic, one must first understand the rigorous and unique nature of the learning process that forms its foundation. In Pillar 1, empowering student learning, there is a process to master practice. LDC's commitment to empowering student learning through CLE represents a significant departure from traditional legal instruction, moving beyond passive academic study towards active, reflective, professional practice. Traditional classroom scenarios often position students as passive listeners, primarily engaged in identifying and discussing doctrinal law. Clinical legal education, however, derives its power and relevance from requiring students to assume and perform professional roles, typically of a lawyer handling a client and their case. Role performance is inherently active, a method that is observed to significantly enhance learning, especially for adults, who learn best when exposed to tasks that are directly relevant to their future professional roles. This experiential methodology motivates students to internalize the law differently. When required to interview, counsel, negotiate, or argue a motion, students are driven by an intrinsic desire to perform competently and skillfully. This ambition compels them to learn the necessary law and action theories, not for the purpose of passing an examination, but for effective application in a professional scenario. This learning environment ensures that while students may enter the Law Development Center having learned the law academically, the CLE methodologies teach them how to use it competently and effectively in practice. According to Professor Don Peters, one of our resource persons who led us in this method, someone from the University of Florida, the CLE approach centers on purposeful action, moving students away from acting merely by habit or imitation towards deliberate professional choices. This is structured around a rigorous three-step process. First is the theory and objective. Before acting, students are required to formulate a reason for their action, define an objective, and adopt a general theory of action. This might involve learning established approaches, such as starting interviews with open-ended questions to encourage broad client narration and minimize distraction from the lawyer or imposition of views. This theoretical grounding is provided through lectures, reading assignments focused on action theories, and critiques of video demonstrations, ensuring a robust intellectual preparation before a practical engagement. This is the practical implementation phase described as the beauty of the clinical method. Students are compelled to translate their theoretical knowledge into actual behavior. These role plays often set up as triads involving a lawyer, a client, an observer, stroke critic. Students must make real-time action choices such as initiating an interview or structuring a counseling session. These performances may be videotaped, allowing students to watch their own behavioral choices. Then the third one is the reflection and feedback. The final step is acknowledged as essential for learning reflection on the action. Students are required to generate feedback by critically assessing what they did and why they did it, and evaluating whether the consequence of their action was effective. This feedback provided by both instructors and peers through discussion, written reflection papers, and journals must be specific, action-focused, theory-connected, and constructive. This mandatory cycle of reflection, thinking about one's action, analyzing their consequences, and adjusting future behavior is recognized as the mechanism that develops the habit of reflective practice. This habit is the ultimate path towards achieving the competence of a master lawyer, defined as someone capable of solving complex practice problems almost simultaneously. The development of this reflective habit links competence directly to the ethical judgment. By consistently assessing action choices against professional and ethical consequences, the system enforces professional self-correction, which is paramount for a practitioner's ethical sensitivity, particularly when confronting real-life ethical dilemmas in practice, such as avoiding bribery or false representations. The training choices embedded within CLE are profoundly consequential for the legal profession and for social justice outcomes. While much of legal training focuses on trial advocacy, the moods that we are familiar with, the reality is that most private practitioners in Uganda are mirroring their counterparts in the US or solicitors in the UK spend the majority of their time on skills outside the courtroom, namely interviewing clients, counseling, drafting legal documents, and negotiating with other lawyers. CLE deliberately addresses this imbalance, ensuring mastery in these crucial non-litigation areas. Furthermore, CLE enforces the client-centered approach, a cornerstone of ethical practice. Traditional legal training often biases lawyers towards viewing problems through rigid doctrinal categories. The client-centered approach, conversely, ensures the lawyer comprehends the client's unique situation, recognizing the non-legal concerns which are typically economic, social, psychological, moral, or political, are often at the heart of the matter and may, in fact, outweigh the purely legal dimensions of the problem. By prioritizing non-legal skills and demanding a client-centered perspective, the LDC LAC ensures that its students possess the necessary competence to facilitate alternative dispute resolution and effective negotiation. This pedagogical choice is the strategic precursor to the clinic's effectiveness in systemic justice reform, particularly in reconciliation, mediation, and juvenile diversion. The training of practitioners capable of solving matters outside the costly litigation system thus directly ensures the successful systemic case relief that the clinic achieves annually. We are now going to talk about theoretical and corporate responsibility as a justice infrastructure. The theoretical rigor of clinical legal education translates directly into quantifiable public service, framing the clinic's work as an essential high-impact component of the national justice infrastructure rather than a discretionary charity. The LDC LAC operational model utilizes its educational function to economically sustain large-scale service delivery. Annually, LDC produces foundational CLE instruction to over 1,000 students. Critically, 164, 100 at Kampala, 40 at Mbale, and 24 at Lira campuses are selected for intensive supervised practical training and are issued practicing certificates. This cohort of supervised students forms the core of operational workforce, enabling the clinic to deliver its exceptionally high volume of core interventions. The structure demonstrates conclusively that the CLE pedagogy economically subsidizes the state's need for large-scale legal aid delivery. The commitment to championing access to justice is evidenced by the clinic's physical and operational expansion. The LDC LAC has successfully grown from a single office at Kampala headquarters to a decentralized network. This network, as mentioned earlier, includes 4 regional clinics located at LDC regional campuses, Sombara, Lira, and Mbale, and for 4 crucial satellite offices, Kabarole, Masindi, Adjumani, and Jinja. This decentralized approach ensures that the clinic services penetrate vulnerable, hard-to-reach communities. The scale of operation is substantial, with the clinic serving over 5,000 clients annually and providing training opportunities to more than 1,000 students each academic year. The quantitative proof. I'm looking at the 2019-2025 data, a period of 6 years, courtesy of LAC. They gave me some statistics. The comprehensive documentation of the clinic's operation over the 6 years from 2019-2020 through 2024-2025 provides robust evidence of its indispensable infrastructural value. The analysis of core service delivery from statistics reveals an average of 8,272 core interventions per year, substantially exceeding the clinic's earlier benchmark of 5,000 clients annually. Over 6 years examined, the clinic delivered 49,629 core interventions, comprising 37,040 legal representations, 5,415 reconciliations, and 7,174 mediations. I will not go more through that. The clinic's operations contribute measurably to national system efficiency and cost avoidance. By combining the average annual core services, about 8,272, with juvenile diversions, that's about 1,083 annual average, the clinic resolves or diverts approximately 9,355 systemic cases each year, away from the litigation-heavy, resource-constrained court system. This contribution relieves pressure on courts, reduces detention and incarceration costs, and lowers the administrative burden on the judiciary. A compelling demonstration of this value is the clinic's capacity as a shock absorber. The data reveals an adaptive institutional capacity, exemplified by the fluctuation in legal representation outputs. The clinic surged from a low of 1,205 interventions in 2019-2020 to 8,794 interventions 2020-2021. This sudden steep surge validates the clinic's role in absorbing system shocks that, if directed solely to the regular court apparatus, would have escalated into severe backlog and system-wide inefficiencies. Juvenile justice interventions highlight the commitment to restorative outcomes. The clinic achieved a total of 6,498 juvenile diversions with an annual average of 1,083, compared to 5,253 formal legal representations, which is an average of annual average of 876 over the 6-year period. This emphasis on diversion, which takes juveniles away from the court system and avoids giving them a bad record for a criminal charge, demonstrates priority of non-punitive outcomes that prevents unnecessary institutionalization, reduces future recidivism, and cuts associated costs of prolonged court processes. The analysis of intervention types also demonstrates a strategic focus on systemic reform. The 2099 annual average of reconciliation and mediation cases, combined with 1,083 annual average diversions, signifies a deliberate, measurable shift away from purely litigation-based curative justice. This high volume of ADR benefits corporate stakeholders by promoting social stability and minimizing long-term institutional costs, framing their contribution as a strategic investment in a stable commercial and social operating environment. We can look at the preventive law and community role of LAC. Beyond curative and restorative services, the LDC Legal Aid Clinic operates a crucial preventive legal educator. The clinic executed 35,023 combined community and school outreaches over the 6 years studied, and this strategy is designed to bring legal knowledge and assistance directly to communities, enhancing legal literacy, increasing compliance with the law, and ultimately reducing future demand for costly litigation service. The decentralization efforts, including the 8 operational offices, are essential for sustaining these geographically intensive, proactive outreach programs. Despite the proven measurable value of to the judiciary, the Administration of Justice Program, AGP institutions, and the nation's systemic efficiency, the LDC LAC's financing remains precarious and project-based. Short-term grants cannot secure the long-term decentralized operations necessary to maintain this high level of systemic relief. The evidence presented compels specific policy actions to secure the future of this essential national resource. Investing in the LDC LAC is recognized as a cost-effective method for achieving core national development goals, including commitment within the National Development Plan, NDP4, specifically strengthening legal frameworks and improving access to justice, and Global Sustainable Development Goal 16, which is justice, peace, and strong institutions. The clinic is demonstrably positioned as a key player within the National Administration of Justice program. To transition from ad hoc volatile support to predictable operational capacity, the data requires a policy change regarding funding. The judiciary, AGP partners, and national planners must recognize the clinic as essential state infrastructure and provide a sustained, dedicated budget, as emphasized by the previous speakers, so that there is a long-term sustainability. To amplify the clinic's impact and ensure high-quality supervision for the next generation of practitioners, the vast resource pool of LDC alumni must be mobilized. A pivotal proposal is required. The Law Council and the Uganda Law Society must be urged to accredit continuing legal education, CLE points, to alumni who participate in Legal Aid Week and other clinic activities. This mechanism creates a virtuous self-sustaining loop. By linking professional regulatory requirements, CLE points, directly to public service participation, the proposal transforms alumni goodwill into reliable, ongoing expert contribution. This secures an experienced workforce pool to mentor the 164 supervised students or more, bolster the quality of supervision, and ensure that the clinic can sustain its high annual case volume, averaging about 8,272, by aligning professional self-interest with the public interest. Now, before I conclude, I just want to give you a few stories about some I left Ministry of Justice when I was a doctrine-focused lawyer, and I did not understand much about what goes on in the lives of those people they put in buses and by the prisons authorities and take to the courts. But I got a life-changing experiences which really made me believe that justice is possible. In one case, which was identified by the students, there was a lady who was charged with assault, occasioning grievous bodily harm. And she spent 4 months in Luzira. We managed to get her in those days, what we call the statutory bail. So with our students, when the time came for hearing, the doctor testified, but the students had a different story. So we were, in our strategy, we did not cross-examine the doctor who testified about the injuries that the accused caused. But the second witness, I was advised that I should prioritize a certain line of questioning. So I asked her who was holding the panga, and she said the complainant. Who was cut? The accused. And we learned, and she asked, do you want Chitufu? Do you want the truth? And indeed, she told the truth. She said this lady was having an alleged affair with the complainant's husband. And they were wives in the police barracks. So they beat her up, and the complainant cut the accused. She was treated from the cells and from prisons. She had a big scar here. So after that testimony came out, this lady unfortunately jumped bail. But we felt that justice had been served, even though she didn't come back for trial. That one was one off. The second case, which is also gendered, is a bit of a young kid of 14 years. She was reputed to be a girl who liked playing with kids. So she was charged with theft of a toy. We appeared here in Mwanga 2 court. So when the complainant was testifying, I was supposed to cross-examine her about why she actually took this young girl to had her charged for stealing a toy. And she says, you see this girl here, you think she's young? She's after my husband. So hello? Yes. So the state prosecutor was a lay prosecutor. They were trained to assist the DPP. He jumped up and said, I am withdrawing this case. I'm entering, is it something? So I knew that he needed the written authority of the DPP. But because the matter was in the heat of the moment, we asked the magistrate, an elderly lady, to dismiss the case. And the case was dismissed and justice was served. The last illustration I want to give is a humorous one. At that time, in 2000, the number of juveniles who were charged for capital offenses was about 80%. And most of it was defilement. We had this 17-year-old who had committed that offense around 16. And the victim was around 15. She dropped out of school. She had the babies, but the police were still investigating. She got pregnant, and we knew there was one period within which prosecution should be done. So one day as he was coming to court, they told us that the victim was visiting. So she came, she had 2 babies. So she brought the 2 babies to Salongo, the 17-year-old Salongo. And Salongo was so happy holding his babies. So we wondered what investigations were continuing. But the police were still continuing investigations until the 1 year ended and the case was dismissed. So legal aid shows you some aspects which you will not get in where you have a doctrine-based teaching. It exposes the students to real lifetime situations, to understanding that not everybody in those prison buses has actually committed an offense, and that there is a story behind those people. Some of them are in for having borrowed money and failed to pay. They are charged with obtaining money by false pretenses, etc. So, to conclude, the statistical record of the LDC Legal Aid Clinic is unequivocal. It is delivering high volume, high quality legal services while training the next generation of ethical, competent lawyers. The foundational success of this institution stems directly from the innovative pedagogy of clinical legal education, which guarantees competence through reflective practice and ethically ground students in the client-centered imperative. This pedagogical strength is leveraged to achieve measurable social returns, resulting in the annual resolution or diversion of approximately 9,355 systemic cases. The analysis compels a clear conclusion. The LDC Legal Aid Clinic is not a tertiary function of the bar course. It is essential national justice infrastructure and a critical system shock absorber. Its continued operation is a necessity for judicial efficiency, social stability, and the realization of national development goals. The solemn charge to all stakeholders today, my Lord, the Honorable Chief Justice, Your Lordships, professionals, teachers, and government, development partners, I recognize Dr. Katia, yes, is the esteemed and our esteemed professional bodies who provide legal aid. The charge is simple and urgent. Recognize the demonstrated value, move beyond precarious funding models, and commit to the sustained institutional support required to serve and grow this success. By institutionalizing funding and mobilizing our professional alumni through incentives such as accredited CLE points, we jointly secure the next 25 years of the Legal Aid Clinic as a core national resource that truly embodies our promise to make justice accessible to all. Thank you very much.
Thank you very much, my Lord, for that very in-depth and informative keynote address. I'm sure we'll have an opportunity in the course of the day to share our thoughts on that, but we thank you very much. As we move on in the program, allow me to recognize a few more guests who have joined us. I want to acknowledge the presence of Dr. Katja Kirschbaumer, the Head of Office, Austrian Embassy Development Corporation. You're most welcome. Allow me also to welcome Dr. Ronald Nalwairo, the Dean, Makerere University Law School. You're most welcome. We also have with us Dr. Patricia Atim Pudong, the Head Legal Aid Clinic PILAC. You're welcome. We have Mr. Henry Cunha, the former Assistant Head Criminal Proceedings here at the Law Development Centre. We also have Dr. Barbara Kitui from the Governance and Security Program Secretariat. You're welcome. We have Mr. Aaron Besije, the National Coordinator, Justice Centres Uganda, one of our legal aid partners. We have His Worship Aiso Nicholas, who is the Senior Principal Magistrate Grade 1 in the City Hall Court, one of our courts that we serve. We have also Her Worship Ms. Esther Nyadoi, the Chief Magistrate Nakawa, I believe, yes. We have also His Worship Oluport Pascal, Magistrate Grade 1 Kajansi Court. You're welcome. We have with us Mr. Kafero Sulaiman, the President, Muslim Center for Justice and Law, one of our legal aid partners as well. We also have our local leaders here in the community, Mr. Leonard Bwire, the Chairman, LC1 LDC Zone. You're most welcome and thank you for hosting us here. We also welcome Mr. Muzei Ronald Mbuba, Chairman, Kivulu 1. You're most welcome. Thank you for hosting us. We have other staff here present from the LDC. I think there are a few other staff, but we also wanted to particularly recognize those who are responsible for managing our fleets and for making sure that the students and the lawyers and the staff reach all their destinations. We have our pool of drivers who are present here with us, Mr. John Tumwesije, Mr. John Warusimbi, Mr. Jacob Okwera, and Mr. Fred Ozunga. We know how critical they are in terms of legal aid service provision. But allow me also to recognize the Uganda Prisons Band, who always entertain us, who keep us alive, who liven up all the occasions. You're most welcome. Thank you for supporting us as always. As we move on in the program, we now have a panel discussion, which will be facilitated by Professor Christopher Mbazira. But as he comes to take his seat, I want to humbly invite our chief guest, the acting chair, my lord, and the director to take your seats there. As you get comfortable there, I'm going to invite Professor Mbazira to come and take over for the panel discussions. As we do that, it is a celebration, and I don't want you to all sit there and get very tired. There are refreshments, there's tea, and other refreshments provided in the tent outside. We will invite you to, when you're ready or when you feel, to just move outside to the side. There are ushers who can guide you there to grab a cup of tea and some refreshments as we continue with this section of the program. So please don't be shy. Please go ahead and have a cup of tea as we settle down for the panel discussion. Professor Mbazira, I now hand over to you. Thank you.
Thank you so much, Rachel. My lords, all protocols observed. It's my pleasure to moderate the panel. We've heard quite a lot. As introduced, I'm Christopher Mbazira. I'm based at the School of Law in Makerere, where I also coordinate the Public Interest Law Clinic. The Public Interest Law Clinic, PELAC, was the first university-based law clinic established at a university in Uganda. We've worked in collaboration with other universities which have since either established clinics or clinical programs, and we pursue this under the East African Network of University Law Clinics, which we initiated at Makerere and have brought on board universities across the region. So the use of the clinical methodology, which is what the LDC Legal Aid Clinic does, is something that is so passionate to us. When we send our students here from Makerere, we are usually comforted, especially those that have gone through the clinical program, that they will find a clinical program at LDC. I was one of the first students that went through clinical legal education. His Lordship, Madrama may not remember, but I was one of your first students. So is Dr. Don Rukare, who are our teachers, and we really appreciate that you laid the foundation which has resulted into this. It's not my day today. My my assignment here is to moderate a panel. Unfortunately, we don't have a lot of time, but yet there is a lot to discuss. I'll try to work within the time that has been allocated for this. To be part of this panel discussion, we are going to have distinguished panelists that have a lot of knowledge, experience working in areas of legal aid and related fields. I will invite to the front the panelists are starting with Ms. Liliana Drico. As she comes forward, we know her, she's the CEO of FIDA Uganda, Uganda Association of Women Lawyers, one of the oldest legal aid outfits in the country. Next to join the panel is Her Worship, Prosi Katushabe. Again, we know she's a judicial officer that has a very critical role to play as far as access to justice generally is concerned, but legal aid as well. Next is Sylvia Namubiru. She's the CEO of the Legal Aid Service Providers Network, a network that brings together legal aid service providers. Indeed, the Public Interest Law Clinic at the School of Law is a member of that network. We also have Mr. John Baptist Asimwe from the Office of the Directorate of Public Prosecutions. Again, we know my fellow legal aid lawyers, you know that most of the time is spent defending people in the criminal justice sector. So we are privileged to interface with you and get to hear from you. Next is Ms. Carol Idembe. She's joining us as well on the panel. Quite experienced with legal aid, especially in the context of CSOs. She's also a trainer in this area. She has interfaced with so many paralegals and lawyers that are working in this area. So that's our panel for today. My apologies. The time doesn't allow us to detail all your CVs. You are distinguished people. So we shall take it from there. I will allocate 5 minutes to each of the panelists, and I will provide some guidance as to what I want the panelists to speak to. But you could also speak to anything that you think is relevant, even if it's not mentioned by myself. We shall take 5 minutes for each panelist. After that, we shall take some 5 to 7 minutes just to get responses or questions or comments or clarifications from the panel, the plenary, and thereafter we shall have some 2 minutes each of us to respond. I'll start with the CEO for FIDA. We know that one of the critical aspects of the provision of legal aid services is gender. And gender is so multifaceted. There is no organization in Uganda that has interfaced with this for decades other than FIDA. So there is quite a lot that you can share with us. What has your experience been? Does for instance, the legal and policy framework facilitate that? Are there some challenges that you faced? What strategies has FIDA used? What are the gaps and how can those be filled? Thank you.
Thank you very much, Mr. Christopher Mbazira. And to the LDC management, thank you for convening this very important celebration and for allowing us to share our experiences. It is true that FIDA has been doing this work for the last 50 years, so we do indeed have a lot to share. And for all the problems that we have had that have come through the different addresses this morning, women are generally disproportionately affected. So I'll start with the economic disparities. The UBOS report says that 45% are living, face severe deprivation. And they mention that it is especially women that face those deprivations. for social services, and so on. We've also noted that 1 out of every 4 households is led by women. And that means that women, their vulnerabilities are compounded as heads of these units at the lowest level. We are also going to talk about the digital divide, and we note that 19% of women have access to digital platforms compared to 27% of the men. So the statistics are already against women, and that is why we need to prioritize gender considerations as we dispense access to justice. One of the barriers that comes out of that economic deprivation is that legal aid becomes very difficult to access. Women can generally not afford legal aid. So that is why we need to have many more legal aid service providers on board to support women to navigate the complex legal systems. Women are equally, disadvantaged by the patriarchy and the traditional norms. Women are discouraged from reporting their cases. Women are discouraged from appearing as witnesses against their husbands, against intimate partners, because the community ostracizes them once they report these cases. So we have cases collapsing on our hands because we are not able to sustain them. The other issue is GBV cases. I'll specifically also mention GBV cases. We have very good initiatives through the courts, through government. We have the plea bargaining that is supposed to help to decongest prisons. But as legal aid service providers for women and children, we find that the plea bargaining session is largely gender blind. It's perpetrator-centered, and because our focus is to decongest the prisons, most times it's not quite rights-based. So the survivors and or victims of these perpetrators are not considered. They are not brought on board as we would want them to be once the judiciary is negotiating the pleas or is negotiating the sentences. So most times, while we will achieve an objective on the one hand, the women are left, they are left in the open. They are not quite listened to through these processes, and they do not get the justice that they deserve. Those are generally the problems that we face. I will just give a few recommendations that we have done or that we have motivated. One of them was raised by Justice Eva. What we have tried to do is practice-wise interest or recruit what we call judicial activists. We have a couple of magistrates right now that have prioritized feeder cases in their system. They give us a day when we can have all our cases heard. I must also add that as a result of the DGF closure and the geopolitics that has happened recently around the world, many legal aid service providers have closed, so the demand for our services is quite high. So we need to collaborate. These issues need a multi-sectoral approach, so we need to collaborate with judicial officers so that these cases are prioritized within the system. The other recommendation is to revise the plea bargaining guidelines so that we ensure that they are victim-centered, they are not gender-blind. That is one other recommendation. The other is to bridge the digital divide. We have a lot of innovations within the judiciary, the judicial systems, but there is no technical assistance given to women that are seeking to use these available innovations. So we need to go an extra mile and ensure that there's assistance that is given to the women that seek these services. The other is to popularize existing guidelines and the laws. I know that we have a clause in the sentencing guidelines that speaks to compensation, but it is not popularly applied as people are dispensing justice. Compensation is deterrent. If you give people, if you have them compensate for the damage that they've caused to the survivors, it will be a deterrent measure, and we will have people who are, perpetrators reduced within the system. The other is to popularize mobile courts. We know that we have very, limited budgets to ensure that that we have all districts with functional courts. I know that Napak, for example, is supposed to have a court, but that court has since been, I think, reassigned to another function. So if we can have more mobile courts within the system, that will help us to take services closer to the people. But it is also one way of acting as a deterrent measure, because the communities know what's going on within the courts and they're able to see the sentences that are applied. I'll leave it there for now.
Okay.
And we can come back to the questions later.
Yeah, but I just have an immediate follow-up question. Just wondering how you deal with the livelihood issues that always emerge when you are providing legal aid. What I mean, somebody comes to you, they are facing criminal prosecution, they are victims of SGBV, but in the process of providing the legal service, you come to learn that actually they have no home to go back to, they have no job from which to derive a livelihood, and they are looking at you as their savior. How do you deal with that as FIDA, considering that the traditional approach is to provide the legal service?
Okay. So
the mic?
It's there, sorry. So what FIDA has done over the years is to evolve through the service provision. Other than just giving legal aid, what we are doing now is to give holistic legal aid. Holistic legal aid includes economic empowerment, and it also includes psychosocial support. So whoever it is that walks into our clinic, if they've come for a maintenance case, for example, we ensure that where we are able to secure some support from the men that have been reported to our clinic, we get the women to get involved in economic empowerment activities. We encourage them to save that money and invest in a viable business venture. We have encouraged them to turn the land that we are able to secure for them into economically viable, activities. So that's one of the things that we have done. And in fact, one of the recommendations that we have shared with the judiciary is to ensure that psychosocial support is institutionalized. I know that it comes with a budget, but if we can institutionalize economic support and not economic support, but psychosocial support through the GBV processes, through the handling of these cases, it is one way that we can achieve holistic justice. So FIDA has been very intentional on ensuring that women obtain training, that we give them seed capital. We have seed capital from UN Women to invest in their businesses so that they can become economically independent, so that they can, have bodily autonomy and become decision makers in their own rights and in the communities in which they are.
Okay, thank you so much. Excellent. Holistic legal aid, an emerging concept. Very, very important. We shall leave it at that for now. Move to Her Worship, Prosi, just to share with us what the judiciary perceived legal aid to be. Is it relevant? Do you put emphasis, as the perception is, on the flamboyant commercial lawyers as opposed to the non-flamboyant legal aid lawyers? Legal aid lawyers are irritant around court. You'd rather get rid of them quickly. Does the judiciary on its own initiative invite legal aid? Please share with us and change our perceptions about how we are treated as legal aid lawyers by some judicial officers. I'll use the word some and leave it at that.
Thank you so much, Professor, for that opportunity. And I would like to start by saying that judicial is one of the biggest or one of the major partners that partners with legal aid. Because I want to start by saying that if you're a judicial officer and you have people who are vulnerable before you when they come, especially in the magistrate's court, your first recourse is to the legal aid clinic. Widow walks to you and they have had some not very good drafted documents by somebody outside there. I don't want to call them bush lawyers, but somebody has done that, and your next recourse is the legal aid clinic. And you invite them and ask them, can you please take on this case? and they are always willing to do that. So they assist us. When there's any issue in the court, and I'm speaking for the lower court, is that legal aid is always the first place that we go to, asking lawyers, asking justice centers, asking the legal aid clinic of LDC to come in and assist those people at that level. But more so is that, the vision of the judiciary is justice for all. And in a bid to achieve that vision is that we need to ensure that there is legal representation for all the people who come to our courts. And being the variances in society, in economic gains, in social, in the social status of the people, it means that legal aid is very important for people who are vulnerable, who are unable to afford a lawyer. So the judiciary encourages legal aid. And at a higher level, the judiciary has come up. In 2022, we came up with the rules of the judicature legal representation at the expense of the state that were put in place and are functional. There's a committee, and I'm proud to say that on that committee, there sits the head of LAPSNet, who is seated next to me, the head of the legal aid clinic here, the manager. They sit there. The representation is across the JLO sector and Uganda Law Society. And what is the role of that committee is to ensure that the quality of representation of people at the expense of the state, which is in essence legal aid, is done very well. And there is monitoring. The teams go to the field, check out what is happening, and then the rules are very rich with forms to fill, feedback from the accused person, feedback from the state attorney, feedback from the court, and we are getting feedback and improving. Every time the monitoring team goes out, it gets information, and we sit and decide on recommendations on how we can do that. And of course, there is no capital case that is heard in court without legal representation. So the ones who can't afford the lawyer, they are given an advocate. It can be an advocate who has been enrolled at, under the rules and is paid by the judiciary. Of course, the program is grappling with underfunding, like any other government program. There is no enough money to pay or to retain so many advocates, but it is the step in the right direction that we actually recognize that representation is very important if we are going to have access to justice for all, if we are going to have equitable representation, and also if we are going to say that we are contributing to economic development. People need to know their rights. I want to say that if you get legal aid, you are able to know your rights, you're able to know how to represent yourself, and also you make the case or the hearing of the matter easy. Procedures are known. Most of the time, the people who fall under the category that go under legal aid do not know their rights. They've come to court, they don't know what needs to be done. So what legal aid does is to help us interview the person, get to know what's the problem, and that makes the processes of court quicker, fighting backlog, and also having an enlightened society. Thank you, Doctor. I can leave it at that.
Yeah, just a quick follow-up. I don't know if you've noticed of recent that the traffic of legal aid lawyers has tremendously reduced in the corridors of courts.
Yes.
And this is a result of unsustainable, precarious funding, as the keynote speaker has put it. Is this something that bothers the judiciary as the judicial budget is increasing tremendously? We've seen the figures. These are public figures. The resources available to legal aid are going down. I don't want to use very bad terms, but we see the state, for instance, of justice centers of Uganda. When we go to the premises of courts and we see them on the other side, many times in a container, does this bother you? Is the judiciary in any way, does it feel obliged to integrate this in their, what I would call a thriving budget?
Thank you, Professor. Definitely the judiciary is bothered, and I want to put a disclaimer that's not only justice centers in containers, even our staff and some of our works and whatever, they are also in containers. those are challenges I usually want to say in the justice system, that, as we grow, as the population grows, as the judiciary grows, is that the infrastructure is not growing at the same rate that we are growing. So in some instances, we use containers. What do I say about the budget? If I may say, is that when the budget increased, there was also some little bit of money allocated to legal representation at the expense of the state. It has improved. It is not where we want it to be, but there's been some improvement, and people can testify that there's been that. Enrolling lawyers, before it would be one lawyer, now you go in a court, there are 6, there are 7, and they are being paid to represent people at the expense of the state, facilitated by the judiciary, if I may say. The integration, that is a journey that we need to discuss. Judiciary is under the Administration of Justice program. So I think that over time, those are things when we meet in the AJP program that we need to discuss. How do we integrate? Of course, we all realize that the legal representation by what would call the NGOs generally has gone down because of funding issues. And of course, when many donors pulled out, that means also the government is strained because it's not being assisted in that regard. So the strain has gone on government, but I'm sure that there are efforts that are being put in place to improve. So we are doing what we can. The rules provide fees that need to be given. We are not giving to the optimum, but we've put it out there to, when we are budgeting, to say that the budget for representation at the expense of the state needs to be increased. But of course, that doesn't cover the civil area. So that other part also needs to be taken care of by sort of a policy. And that's why I say that I want to thank the legal aid service providers, especially in the lower courts, that they are helping land, family, etc. Thank you.
Thank you so much. Interesting. Something to discuss further, if time allows, considering, for instance, can we integrate the budget of the justice centers in the mainstream budget of the judiciary? Her Lordship, the principal judge, is here. Something to think about. Should the head of justice centers be at the level of the High Court judge? Probably. Aaron, I'm joking about that. That was a joke, but just to put in a bit of issues to consider. Sylvia, sometimes I sympathize with you. You have made noise, you've shouted, you've attended every forum where I think your voice is going to be heard. I don't know how many times you've spoken about the legal and policy framework. At some point, I saw you excited when you said, finally, there is a bill in Parliament. Then, it fizzled away. Sometimes I sympathize with you. Aren't you stressed? Looking at the National Development Framework from NDP 1, at some point NDP 2, NDP 3, we get excited. We say, finally, justice issues at the center of national development. Is NDP 4 doing the same? Has your voice been heard?
Very interesting. Yeah, thank you so much. And I want to congratulate the Law Development Centre for this milestone. And on this note, I recognize that the Law Development Centre Legal Aid Clinic is a founding member of LASNet. Madam Theo Wevale housed the first national coordinator. So the shouting, the calling, the frustration has not been a lone voice alone, but all the legal aid service providers in support and the development partners. I can see Dr. Katia here. He calls me Miss Legal Aid. I think that's what she calls me whenever she finds me. So we have been in this journey. And I must say where we are. Yeah, all hope is not lost. This morning I heard the Honorable Attorney General saying the government of Uganda is committed to providing support and sustainable legal aid. I would like to say that the lenses should not only be pointed to LAC, because LAC alone cannot handle the needs out there. 80% of Ugandans, it is a research, cannot afford services of the flamboyant lawyers. And those 80% of Ugandans are mainly the poor, the vulnerable, and marginalized. And so when we are talking about the National Development Plan, which is looking at Vision 2040, those are the people we are looking at. And we need to improve them from their vulnerability to a level when they can get better. So our call as the legal aid service providers sector is to see that the government of Uganda puts legal aid at the core of national development. And it becomes a priority, not like we see only health care or education care, but a priority in terms of the tangible benefits it gives. That is, promoting access to justice and addressing the justice needs of those who may not traverse in the justice system. We are talking about the congestion in prisons, take away 20% of those who can afford the private practitioner, leave the rest of the 80 to those who need legal representation. We are talking about the innovations and fast-tracking them, like the plea bargain. It is not enough to count numbers of plea bargain, but the quality outcome of the plea bargain. And these people who are under incarceration will need the services of the lawyer to guide them through the process, to make informed decisions. We are talking about legal land rights, property rights. Again, we are looking at the 20% that are vulnerable to the land grabber, the one who is a 20% who can go to the practicing advocate and be able to pursue their rights. So I can go on, but we need to look at legal aid in the cost-benefit analysis. What is the cost-benefit of having legal practitioners providing quality services? What do we stand to gain as a country within the context of the National Development Plan? If we have people getting their justice needs met, either in commercial justice, either in civil justice, and in criminal justice as a whole. And we should not forget, we've been praising the lawyers, the social justice lawyers, but they are just a small percentage. But the Law Development Centre annually is channeling out over 3,000 into the marketplace. Who is absorbing these lawyers? And we are subjecting them to being vulnerable within the private sector setting. The government needs to be the biggest employer of the lawyers we are channeling out. And that is when they are placed in the different sectors, not forgetting the defense. Because we have the judiciary, and we have the DPP, we have the prisons, we have the police. But what about the equation of the defender? Is it matched? We've been talking about the ratio of the judicial officers to the prosecutors, and this has been part of the discussion, that the judiciary is now increasing in number, but the prosecutors are less. The same is applying in the litigation sector, that when the 20% have no one to represent them, then the end result is that there's no justice served. I want to come also, in conclusion, to the issue of employment and giving examples. That while these lawyers that are providing legal aid are looked at as at the periphery, in other jurisdictions they are celebrated. Let us look at Legal Aid South Africa, a brand, the most sought after employer in South Africa. Why? Because the government made a choice to invest in legal aid. But also there is a relationship between public and private partnership. There are cases that Legal Aid South Africa cannot litigate, and they will always be outsourced in the private-public sector. So when we are talking about the non-state actors that are providing legal aid, 40 years of service, like FIDA Uganda, 50 years and above, and now 30 years plus, Legal Aid Project of Uganda Law Society, and many more, including last month that is now about 25, is coming to 20. It is 20 years that is coordinating and bringing the actors together. We need to be mindful of the fact that there's that complementarity, and therefore I will end by saying that whereas we have the Advocates Act, whereas we have the regulations for indigents, practice directions, we need to have a robust and comprehensive state-funded law that creates a body or a legal aid service provider that is more sustainable because the government of Uganda will be investing resources, and as a result, we shall be able to invest in other sectors of legal aid, including expanding to oil, expanding to farmers, expanding to ICT, so that we leave no one behind. I thank you.
Sylvia, thank you so much. Very eloquent as usual, very passionate as far as access to justice and legal aid is concerned. But those of us in the Ministry of Finance that are driving this country to middle income, by the way, are we already there or we are getting there soon? But those of us that are driving the country to there, we think our resources should go into infrastructure. Our resources should go into infrastructure. You are now telling us that we should waste some of our resources by providing legal services. What is the connection?
Okay.
Yeah.
The connection, of course, comes with, first and foremost, our commitment to the international legal and policy framework, the right to a fair hearing, the right to access justice under the different conventions that government of Uganda has ratified. Then the sustainable goal, 16, that speaks about inclusivity and promoting peace and security. Yeah, so when we are talking about peace and security, we would not be talking about we only need infrastructure. Then the question we ask, why do we need prisons? Why have we invested in prisons? Why are we invested in courts of law? It is because these institutions make a contribution to the national development. And also, when sickness is not only physical. I can be sick when my mind is not at peace, my land is being taken away, my children are neglected, yes, my property under administration of estates cannot be secured, you know, I can be at peace, gender-based violence in the homes, you know, domestic violence. So even if I am not sick in body, but I can be sick and I cannot contribute to the national development if I don't have assurance of preservation of my property rights, of where I know that tomorrow I'll be evicted from this piece of land, of where I know that I'll be in prison for the next how many years without getting justice. So the government of Uganda should also look at the issues of mob justice that arise when people are not empowered and there's no prevention using some of the innovations like paralegalism. The government of Uganda should be concerned when there is lawlessness. So investing in justice is a cocktail. It's not one-off, but it has economic opportunities. It has social benefits, social cohesion. It has the contribution to the wholesomeness of the human being that is now going to contribute to the national development. So let us look at legal, health, education as all complementary, and the national budget should be evenly distributed.
Okay, thank you so much, Sylvia. I will move to Carol, Madam Idembe. You've committed your entire professional career, I know, to access to justice. You've worked in the CSO sector. When I look at you, I sympathize with you. The CSO sector is dying away. It is not, it's no longer able to get the funding. I'm just wondering what sustains you and how you look at the policy framework. Does it facilitate what you are doing? Is all, you know, gloom, or should we have hope? Thank you. Microphone, yeah.
My passion is really for the indigent person. Even when I was a little girl, I didn't want people to fight. I would always want to settle people who are fighting, and I think it's part of my DNA. But I just realized that even as an institution, even as players in the whole legal aid fraternity, we need to think through about the National Development Plan. It is moving also the Vision 240, moving from a peasant economy to a prosperous economy. And when you look at the National Development Plan and the Vision 240, by 240, everybody should be having at least annually $9,500 US. And I think we are 15 years to 240, and I don't know whether we will be there. Because already 3 national development plans have shown we are short of that. And that will mean we need to change the trajectory, we need to change the way we see things. And I'll first look at the Law Development Center, our director, our distinct director. We need to begin looking through what we are going to train our students. Because the programs that are in the National Development Plan 4 are talking about tourism, are talking about oil and gas, are talking about manufacturing, are talking about ICT. And I don't know whether our graduates, when they come here, they are really prepared. And I think we may have to think through that. If I come, maybe I probably will come for a postgraduate diploma, but specializing in agriculture. So that when you go in that industry, you know what is there. There are middlemen who are taking advantage of our farmers. They come and buy at a very low price and come and pay and sell at a very high price. But who is there? Who's observing that? Who's going to make sure that they even have contracts between the middlemen and also the farmer? So we need to begin training our products here so that they respond to the National Development Plan 4. In oil and gas, I mean, where those pipelines are passing and whatever, I know there are people who have not been able to be compensated well, especially women, because the male gender is the one that owns, in most cases, the land. So when they are compensating, will they compensate Carol, whose name is not even anywhere? Of course, me, I'm empowered. My name is everywhere because of my education. But the majority. So who is compensating? I know there's a time where I was working with Intelligence Council of Uganda, we realized that many of the women were not compensated. Why? They are cohabiting. And so when they are calling for the owners of the land to be compensated, you're nowhere. But you have produced children for the last how many years? You've been in this so-called relationship for the last 40 years, but you never be compensated. And one of the bad things that happened, when the man gets the money, he leaves you here and goes and gets a new family, the one that will benefit from the big pay. So we need to begin empowering, responding to what is happening in the National Development Plan. I want to also say that ICT is one of the programs. But yesterday when I listened to the TV and the Bank of Uganda was saying the majority of people who are stealing money through the cyber system, digital, they were able to arrest, I think, 107, and they were able I think out of the 7, only have one successful case prosecuted and person sentenced. But the money that they were talking about is over 500 billion. So if I'm a lawyer outside there, will I understand that industry? So we need to begin saying, maybe let's open up. I may come here to specialize in cyber security, but give me a postgraduate diploma in that particular sector, so that when I go out, I'm a specialist, but I'm not solving all the problems of the legal world. And then lastly, maybe probably even tourism, because that's one of the areas. Do we understand as lawyers the tourism industry. Do we understand it? You generally write even a contract because you don't understand what is there. But probably we may have to say, I'll come and specialize and do my postgraduate diploma, but specializing in tourism. And then lastly, are we able to provide the legal aid specifically in that particular sector? Because if I'm not trained into it, how will I be able to give legal education, provide legal services to that particular sector? Because I'm outside it. So I want to say it's an opportunity for us to be able to turn around and be educated about the National Development Plan and be able to respond to the needs of Uganda, because I want to be part of the $9,500. Thank you very much.
Okay, thank you so much. Carol, I see very passionate about legal education and its connection to the profession. I've also known you to invest a bit of time in capacity and institutional development for CSOs. Could you talk to us about how we get out of this financial ditch in which we are? How do we build sustainable funding? You remember we had this conversation a few years ago. We are still where we were. How do we get out of that? Should we still be looking at the state? Is the state going to rise to the occasion? If it does not, how? Lillian here is thinking about it seriously. She's not sure FIDA will survive the next so many years if nothing is done about that.
I think we need to expand. I first learned about how CSOs are able to respond to the needs and also raise money within their economy. It's in US. When I visited, I was one of the alumni on their long global program in 2008. It was my first time to go to the US. And so I visited many NGOs. And when we asked about the funding modality, they were telling us they don't get money outside the US. So we said, okay, if you don't get money from the US, where do you get it? You'll find an institution like NAPSNet or FIDA having another arm of doing business. That particular arm will be able to have maybe estates dealing in land, and they will be able to sell. It will be on the market like any other. The money that comes, the proceeds that come out, it goes now to the charity. So I realized, I think we have been sleeping, thinking that we'll have charity, people will give us, but we can create our own charity.
Okay.
And so lastly, personally now I'm in agriculture.
Okay.
So I'm not only doing capacity building, but I'm into poultry, I'm into piggery, I'm into cattle rearing. And let me tell you, the economy speaks for itself. I'm doing it in Ivupla, Namtomba district. But people come and buy my chicken, and they tell me, do you have 500? Do you have 1,000? It will be cheaper than selling it here, but I still get a profit out of it. I'm not going anywhere, but they are looking for me. So even as institutions, what are we doing that is responding to the economy so that we can have that arm of doing business and then the money comes to the charity? Okay. I submit. Thank you.
Thank you so much. You've really challenged us. You've challenged FIDA here. FIDA Mixed Farm, FIDA Hotel and Resort. Who wouldn't want to buy eggs from FIDA Mixed Farm or take milk from a FIDA cow? So, Lillian, think about it. Thank you so much. Amicus Mixed Farm, of course, is there. I'm also a farmer. Like you, I do the same. I also sell chicken and stuff like that. Thank you so much, our panelists. I'm going to open up a bit. We are running out of time. Sorry? Oh, sorry. I'm forgetting Mr. Asime. My apologies. My apologies, Council. Yes, Council, you have your 5 minutes. We know as prosecutors, you are obsessed with your badges. And your badge is the number of convictions that you have. When you retire and hang in your boots, we judge you by the number of your convictions. And don't you then see legal aid as an inconvenience? Do you ever advise judicial officers to adjourn a matter to enable the accused person get legal aid, or you simply do what we hear you do? Most investigations are still going on, like was the case of Salongo. Now share with us what the ODPP thinks about legal aid.
Thank you, Chair. Also allow me to congratulate the LDC Legal Aid Clinic upon this milestone of providing legal services for the last 5 years. As prosecutors, the office of the DPP, of course, you all know, or most of you know, that the office of the DPP is mandated basically to institute and prosecute criminal cases in courts of law. However, as we do this, we need to be mindful, or we are mindful of our basic human rights, and one of them is a right to a fair hearing, which is provided for under Article 28 of the Constitution. And a person cannot have, you cannot talk of a fair hearing when a person doesn't have legal representation. And therefore, it is very important that we as prosecutors, we have to balance this to ensure that a person gets a fair hearing, much as is being accused of a criminal offense. Secondly, there is a presumption of innocence, that the person is presumed innocent. The person who is charged with a criminal offense is presumed innocent until he has been proved guilty or pleaded guilty. This one, as prosecutors, we are obliged to ensure that we adhere to this. And under the same article, it is provided for in respect of particular offenses that they cannot be tried without legal representation. And these are offenses that are punishable by a sentence of life imprisonment or death, what we call capital or semi-capital. So as prosecutors, there is no way we are going to prosecute a case and get a conviction. The person has not been legally represented. But again, there are other type of cases a person should be legally represented, have access to legal representation. We, at the Office of the Director of Public Prosecutions, we are mindful that in doing our work, we should ensure that people get access to justice. And therefore, legal aid is very, very important as far as we are concerned, as far as our work is concerned, because it provides assistance to the poor, the vulnerable, the marginalized in the society, by enabling them to access justice and enforce their rights. It also promotes quality before the law, as justice would be dependent on one's income or financial ability. So even those ones who are not financially advantaged be able to this through legal representation. Of course, as I've talked about hearing of these cases which are mandated under the law to be accused persons to be represented, if we don't have such an intervention or services of legal aid, we definitely are going to have case backlog increasing, and having these services help us to reduce backlog, and also to helps us to create awareness or public awareness on people's rights, not only for the accused persons, but also to the people who are involved in the criminal justice chain. And through outreaches that have been done, most of the cases that would have come to the mainstream justice system have been diverted, especially those ones involving juvenile offenders or opete offenders. And even those ones that are already in the system, legal aid has been also helpful for us, to us in interacting with the accused persons who are on remand. When we are conducting pre-bargaining, for example, one of the initiatives that we use in our system, it is legal aid which mostly interacts with the offenders who are in prison, talk about their cases, sensitize them, and they have become so instrumental in this pre-bargaining project. Of course, they also play a big role, as our keynote speaker mentioned, prevention. Of course, as when we talk about crime, people we tend to think that we come in when the offense has been committed, but it is very, very important to be mindful that we need to address the causes of these offenses so that we don't continue receiving many cases in the system. So I would say that we cannot operate without these services, and therefore legal aid services is very, very important to us, for us if we are to fulfill our mandate as the office of the DPP. Thank you.
Thank you so much, Mr. Asimu, and thank you so much for giving your presentation within the time. But I want to ambush you and put you on the spot, because when you do this, you make our work very hard, those of us in legal aid. Why do you sanction files which are not fully investigated? And at the song we hear, investigations are still incomplete. Investigation. Why? Why do you make work hard for us? We are running between courts, only to be told investigations are still ongoing.
Yes, thank you, Chair. That is a very controversial question. That to understand it, you need to first know what the stages that the case go through, and the different actors that are involved in the process of investigation. Unfortunately for us as the ODPP, it comes to us at a certain
Mr.
age.
Sim, now you are being theoretical. Please
No.
answer my question. Why
I'm
do you
coming to
sanction
that.
files that are not fully investigated?
We don't do that, and I want to state it categorically, that before a case is sanctioned for court, the evidence must pass a certain test.
Okay.
And that is a test that we apply to all cases. What remains is just a few things to put together, and then it's complete. And for us as ODPP, when we sanction, then the completion of the remaining minor inquiries is done by another institution.
Okay.
So we don't sanction cases when they are not ready for court.
Okay, we shall continue with this discussion in another forum. I know it's a very controversial one, but congratulations, you've attempted to explain to us. Whether we are convinced or not, that's another question. Otherwise, this is my panel. I'm going to open up a little for 3 minutes to hear from you in case you have a comment, a question, a compliment, or anything for the panel. I'll just give a few persons, but I want to begin with the Vice President of the Uganda Law Society, who initially was supposed to be part of this panel. Unfortunately, we got information that you are caught up somewhere. Share with us, legal aid, how does it fit in the vision of the R&B, Radical New Bar? What is happening to our legal aid clinic there? Is it thriving? Does it fall in the 4Ds, or is it on the periphery? Educate us. You have some 3 minutes before I invite other persons. I see Dr. Kakoza was the first. I'll come back to you shortly. Yeah, sure.
Thank you, Doctor. I'm sorry I had to give myself a podium so that I'm able to communicate to everyone in the hall. A good morning to everyone, and like Doctor has rightly stated, I was a bit caught up in another engagement at Makerere. Nonetheless, I made it here. I bring you greetings, all of you, from the Radical New Bar Governing Council, specifically the President and the entire Council. Allow me congratulate the Law Development Centre for, this achievement. It's not a mean achievement, celebrating 25 years of legal aid. At the Uganda Law Society, we've offered legal aid for the last 33 years. And the unfortunate bit is that I believe all the speakers have been talking about this, that legal aid in Uganda has been left to, I'll call it private individuals or institutions, because the government has completely refused, failed to take up this aspect of legal aid as an important aspect that contributes to the social economic growth. Even when you look at the Vision 2040 for Uganda, the aspects of development, really, you cannot achieve that if you have even simple disputes not being resolved. Now, I heard the speakers talk about the obvious, the constitutional provisions. Article 28 talks about a fair hearing, and according to Article 44, it's a non-derogable right. Now, unfortunately, as you heard my namesake speak, in Uganda, the only area where we have, this attention is representation of people in capital offenses. And that is where the state provides legal aid or, provides an advocate. But the other question is, at what stage should you even have this legal representation? They usually allocate these files to us. I'm a proud state brief lawyer, which I've done over years. Over the past 10 years, I've done legal aid. I've also done a lot of state briefs. They give you this file when the case has been cause-listed for hearing. But remember, this person was arrested years ago. The time they're making their statement, the time they're recording a charge and caution statement, the time all those steps are being taken, no legal representation. That's why you sometimes go to prison and find prisoners telling you that I only saw my lawyer here in court, because that's the time this lawyer is actually appointed. And the lawyers actually become bad. They look like they do not know what they're doing, or they're not doing the right thing, because you didn't get instructions at the right time. But that is not the only issue. You take note that whereas the government or the legal regime only focuses on capital offenders, in criminal matters, there are other areas. The Hill report on the Justice Needs and Survey, I think the one of 2023, has clear statistics that 80% of Ugandans have serious justice needs that require support of a lawyer. Unfortunately, only 15% Ugandans have been able to access justice through courts. And one of the reasons is because they do not have legal representation. Now, the rest of the Ugandans, close to 80%, seek justice using alternative means. Interesting, even in those other alternative means, they require legal representation, legal guidance. Unfortunately, they do not have this because clearly the majority of Ugandans are very poor. They live below the threshold and cannot afford services of a lawyer. And this is the cry we've been making, saying there is need to focus on enforcement of this right, the right to a fair hearing, right to legal representation. How can the government take part in this? We've seen countries that have moved. Most of you must be aware that I think since 2016, we've been pushing for the national legal aid law. Dr. Sylvia here speaks passionately about it because at the beginning we were together while trying to push, advocating for this, looking for private members to push it in Parliament, and it is being shelved because we need a certificate of, financial implication. It's not looked at as a priority, but look at the impact this issue of, failing to have disputes resolved properly. What is it having? I was also sharing with colleagues, we have an Advocates Act of 1956. It's colonial. when you talk about decolonization under the Radical New Bar in our Vision 2060, those are some of the things we are talking about. How is the law being responsive to the current needs? Because if we had a review of that act, probably would have, scenarios where there's alternative billing for advocates, considering the people cannot afford. Well, would have maybe paralegals taking up certain, cases. You've been talking about the current state of prison, 79,000. That is the crowding in prisons. And how many people in those prisons can actually afford services of a lawyer? So you realize the state of legal aid really is in a dire state unless we think as a country and we refocus. Because if you notice, and I believe the speakers have talked about this, Dr. Massa have talked about this, in the recent past, the donors are also, there's what we call donor fatigue. Around 2021, DGF, which was the biggest donor, pulled out. Now, most legal aid service providers, those ones who do not have the backbone, are pulling out. Offices are closing. And because they do not have that kind of support, they've been heavily relying on donor funds. We are facing that same issue at the Ugandan Society because the members, much as have over 7,000 members, they pay subscription. The members' money is not enough to sustain the legal aid project. And even in some areas where I have clinics currently, we had to scale down, so we are not taking on new clients. You've seen even the legal aid clinic of the Law Development Centre, largely, it's a government institution, but largely most of the interventions are donor funded. Talk of the laws we have that are not really matching. If you look at the Children Act, there's even a provision that a child who is being produced in court, they must have legal representation. There's even that word legal aid. But the question is, where's the legal aid and who provides this legal aid? Because legal aid is really left at the mercy of individuals who can come up with these initiatives and try to look for the funding. So the biggest challenge we are facing is the funding challenge. And if it is not attended to, if we do not take this because we can't continue relying on foreigners, on donors to come and help us solve our problems, if the government does not see this as an important aspect, and, we think this legal aid law, the National Legal Aid Law, which has been pending in Parliament for so long, should really be fast-tracked. We have examples. Kenya Cross has done that. Other jurisdictions, Rwanda has a policy. I think Dr. Sylvia and the team went to South Africa and saw how the policy works, how the public defenders are empowered, and these are government programs. Okay. So generally, my thinking is that legal aid is really very necessary because we cannot move as a country where majority of Ugandans, 80%, cannot afford to pay services of a lawyer, and then we are saying that we are leaving legal aid as an alternative for those who are able to provide the service. This should be a national issue, and we should all get up in arms and push for this. Okay. It's a constitutional right, and it's the duty of the government to ensure that these rights that are enshrined in the Constitution are actually observed, and the public or the members of the public or the citizens are able to enjoy those rights, most especially that right being non-derogable under Article 44.
Okay, thank you. Thank you so much. Mr. Vice President, our Vice President, I had a follow-up question, but you answered it. I was going to ask, and what D addresses the challenges that you've outlined, but you talked of decolonization. As you go back later, you could educate us on how demilitarization can address the challenges we are facing in legal aid, democratization. We've already spoken about digitization and the other. Thank you so much, Mr. Vice President. Madam MC, I see you have something you want to say. Okay. Okay.
Ladies and gentlemen, the panel will continue. We will have an opportunity to continue the discussion, and I'll just request the moderator and the panelists to remain where they are. But we want to just give an opportunity to one of our key partners. We've had our development partners who have been supporting the cause of legal aid for many, many years, and they are represented here by Dr. Katja Kerschbaumer, who is the head of office, Austrian Embassy Development Corporation, but she's also the chair of the Justice Development Partner Group. And we'd like to give her an opportunity to speak, after which we shall resume with a panel discussion.
Thank you, Rachel. Thank you for fitting me in. Unfortunately, I have a very, very busy day today, and I'm trying to make it work somehow. The Honorable Chief Justice of the Republic of Uganda, represented by the Honorable Acting Principal Judge, the Honorable Attorney General, Justices of the Courts of Judicature. I've seen Justice Madrama, I've seen Justice Luswata, the Director of the Law Development Centre, Dr. Pamela, with the hardest name. I think I've gotten pretty good with Ugandan names, but her name is still. So Dr. Pamela Tibihikira Kalyajira, I'm trying, the Chairperson of the Legal Aid Clinic Advisory Board, representatives of the judiciary and the justice, law and order sector, development partners, members of the academia, I've seen Professor Mbazira here, civil society leaders, LDC staff and students, distinguished guests, ladies and gentlemen. It is a great honor and privilege for me to join you this morning on behalf of the Austrian Embassy, on the one hand, but also in my capacity as the chairperson of the Justice Development Partners Group. I am happy to celebrate this historic milestone of 25 years of the Law Development Centre Legal Aid Clinic with you. Today's celebration is really not only a commemoration of the longevity, but also of the impact, partnership, and purpose of the Legal Aid Clinic. For a quarter of a century, LAC has stood as a bridge between the law in theory and the law in action, between the promise of rights and their realization for thousands of Ugandans. When the clinic began in 1999 as a small office within LDC, few could have imagined that it would grow into the vibrant multi-regional institution it is today, with branches across Kampala, Mbarara, Mbale, Lira, satellite offices in Kabarole, Masindi, Adjumani, and Jinja. Over the years, LAC has provided legal aid to more than 5,000 clients annually and trained over 1,000 students each academic year. It has supported the decongestion of prisons, it has promoted mediation and reconciliation, and helped to reduce case backlog, contributing directly to the justice, law and order sector, the JLOs, and the goals of the 4th National Development Plan. The clinic's model of pairing advocates with bar course students under close supervision is truly exemplary. It simultaneously develops professional legal skills and delivers quality, cost-effective legal services to the poor and vulnerable. Through this, LDC and LAC have produced generations of lawyers who not only understand the law, but also appreciate its human face. Lawyers who recognize that justice is most meaningful when it reaches those most in need. Austria is proud to stand beside the Law Development Centre and the Legal Aid Clinic in this mission. We have provided support to the JLO sector, represented by Rachel here today, for almost 20 years. And we have chaired the Development Partners Group multiple times. By doing so, we always had a very close relationship with LDC and with LAC. In the current period, Austria is supporting the clinic's community and prison legal outreaches in Lira and Adjumani, empowering communities through legal sensitization, mediation, and diversion mechanisms for juvenile and petty offenses. These interventions not only expand access to justice, but also build public trust in the justice system and they also promote restorative solutions. Our support to LDC perfectly aligns with Austria's governance and human rights program in Uganda, one that seeks to strengthen institutions, to empower citizens, and to uphold the rule of law. It also reflects Austria's core belief that development and justice must move together. The Legal Aid Clinic stands out for its innovation in clinical legal education by blending classroom learning with real-world practice. LDC has demonstrated that students learn law best when they see how it touches people's lives. Through ADR, court annexed mediation, and community sensitization, the clinic has also helped to resolve disputes peacefully and to reduce the burden on the formal courts. It also has strengthened the confidence in informal systems, and it inspired the next generation of lawyers to be not only advocates, but to also be agents of social change. This is a model that many countries can learn from, a model that places the people at the center of legal education and justice delivery. As the clinic marks its silver jubilee, this celebration is as much about the future as it is about the past. I commend LDC for its forward-looking strategy, engaging development partners, engaging private corporations, and LDC alumni to support the clinic's continued work. These partnerships will not only achieve results, but also create a community of champions committed to justice and service. As development partners, we recognize that our role is not merely to fund activities, but to walk alongside institutions such as LDC Lac, sharing knowledge and building systems that endure long after projects end. Austria is committed to continuing this partnership, supporting policy dialogue, capacity building, and innovation in the delivery of legal aid and justice services. As we mark this silver jubilee, let us celebrate the founders who envisioned this clinic, the advocates who mentored the students, the partners who walked side by side of Lac, and the communities who trusted you with their stories. On behalf of Austria and on behalf of the Justice Development Partners, I extend our warmest congratulations to LDC and the Legal Aid Clinic for 25 years of dedicated service. May the next years be characterized by innovation, sustainability, and an even stronger commitment to making justice accessible to every Ugandan. Thank you very much.
Thank you very much, Dr. Kirschbaumer, and thank you to the development partners and to the government of Austria as well that you represent. We appreciate the remarks and the continued partnership. With that, allow me to hand back to Professor Mbazira to continue with the panel and the discussions.
Thank you so much, Rachel. I continue with the plenary very short. We are going to keep it short because we've run out of time. Professor Kakoza, I saw your hand up. Your Worship, I see you. I see Dr. Patricia Atim. Okay, for now I see Afande from Uganda Prisons and then our colleague at the back. I think let's move in that order. So the mic, let's have Professor Kakoza here start. Please keep it brief.
Thank you very much, Professor Bazira. We're just having a chat here with my friend, Madame Jen Okot-Piptek-Langoya, about the fact that when you look at the statistics, students in law schools who have gone through legal aid clinics tend to perform much better than the rest, and I'm sure yourself know that. So why don't we make legal aid clinics in law schools mandatory? I mean, now we have, I don't know, Madam Secretary, is it 20 law schools? 19 law schools in the country. 17. if it make it mandatory, we'll deal with one stone hitting many, one stone hitting many birds. That you have the challenge of few legal aid service providers being dealt with, then you have more people being exposed to ADR, then you have more people turning to the small claims courts because the students who work through legal aid clinics can bring that exposure to them. So that's one suggestion.
Okay, thank you, thank you. Your Worship, here, and then Dr. Tim.
Thank you very much, Dr. the moderator and panelists. My name is Doku John Paul, Registrar Planning, Research and Development in the Judiciary. I'll just talk on two things. One, legal representation is very key. Just yesterday, the Law Reform Committee of the Judiciary, chaired by Her Lordship, the acting principal judge, passed the Constitution, child-friendly standards and procedures practice directions. One of the key provisions in that practice direction was legal representation. And therefore, legal aid becomes very important in this. So it will go through the final stages then published. The other, Doctor, you mentioned earlier about the Justice Centers Uganda. It was not that that you were joking. Actually, just Wednesday, as we were reviewing the draft Judiciary Strategic Plan 6, this matter came up on the Justice Centers Uganda. How can it be supported under the judiciary? So that is a discussion that will continue, and I believe the top management of the judiciary will make a decision on that. Thank you.
Thank you. Thank you so much. Dr. Tim?
Thank you so much, the moderator, Professor Mbazira, and I greet everyone here and recognize you in your respective capacities. My comments from the plenary, rather the discussions that we have had, are about 5. One, let me pick it up from where Professor Koza left off. The role of university-based law clinics in promoting access to justice and building a human resource that is aware and ready to provide access to justice and enhance justice, legal aid in this country. Professor Kakoza introduced us to the role of the university law clinics. Let me add from our experience in PILAC, where we engage with Professor Mbazira, the problem is still funding. The public interest law clinic at the School of Law, Makerere University, is about 13, 14 years old now, but we have largely engaged, implemented our activities with support from donors. And now the donors are closing out. That means also our university-based clinics, if they are not supported by government or the university or the ministry, they will also close, and the initiatives around building capacity of law students to provide justice, social justice, and develop skills and enhance provision of access to justice and transform legal education, make it more practical. Justice Madrama talked about the clinical legal aid program and all the benefits it gives students, is going to fail. So my call here is for the powers that be to find a budget as a country for universities, to support universities in the provision of clinical legal education and supporting legal aid roles that can be played by the universities. And I know there is now the Governance Social Security Program. Maybe we can fall under administration of justice or the jail sector, and the players are here. Please find where you will find a budget for universities to run these clinical programs and be supported maybe by the donor partners. Secondly, the issue of juvenile justice. At PILAC, we have a grant, a donor-funded project to support representation of juveniles, which we are doing in Naguru and Kapiringisa. Those remand homes are often crying of the overcrowding, lack of transport facilitation to take juveniles to court, causing delays in accessing justice for juveniles, etc. So my call to the judiciary here, have operationalized the juvenile centers as courts, or at least they were gazetted as courts. I hope we can, there's the worship on planning and so on, they are here. I hope we can now pick it up and operationalize so that access to justice for juveniles is improved in the sense that the OCs do not have to struggle with transport issues. Juvenile cases can be heard from within the juvenile homes, and it's expedited within the requirements of the law. And then also provide sufficient funds for the resettlement and reintegration of those juveniles. At PILAC, we are supporting the juvenile homes now to support and reintegrate because they are overcrowded and they are stranded with children. Then embarking on alternative sentencing because of the overcrowding. I hope the DPP is going to listen to that, taking on measures and improving our alternative sentencing mechanisms so that cases like, I don't know, a child has stolen a toy can really be addressed in another manner without remand or incarceration, and providing psychosocial support for our suspected persons or accused persons. Just like Justice Madrama said, these people have a whole baggage of things. They may be criminals or committed crime, but because of many other factors that need psychosocial support. And yet our court systems, the prison systems, do not have provision for psychosocial support.
Okay.
Yes, thank you very much.
Thank you. Thank you so much, Dr. Tim. Our colleague here from Uganda Prisons.
Yeah, thank you very much, Professor. Protocol observed. Once again, Milton Tio. I'm Assistant Commissioner General of Prisons in charge of correctional services. I'm here in two capacities. One, I'm representing Commissioner General of Prisons. Then secondly, I'm representing myself. I'm happy that I'm here because I didn't know that I'm known because I got invitation as Milton Tio. So I'm very, very happy for LDC. I'm really confirming the role of legal aid and legal aid education to Uganda Prison Service, the role they're playing in decongestion. I would have commented on all the discussions here, but I'm not going to do that because of lack of time. I just want to confirm that they are doing a lot of work. Some 2 months back, my unlock is the number of people you lock, had gone to over 80,000. But as I talk now, it has reduced a bit. For your information, Correctional Service has 3 departments. That of self-custody. I'm the one actually I'm the custodial of the keys. I lock and unlock. If I'm not happy, I can decide to lock and just cross to Congo because I come from Arua. As I talk now, last evening, I locked up 78,133 prisoners. Now you're going to see your role you have played. I have 42,257 convicts, which makes 54.1%. Then it remains, I have 35,274, which makes 45.1%. Here we are very, very happy. Actually, the lower the remand population is better for us because we have actually space for convicts in our farms. Congestions we're talking about are in towns and cities. Then I have 597 judgment debtors. These are people who borrow money and they refuse to pay. And 303 children. These are children who are incarcerated together with their mothers. And all these are taken care by only 14,500. Why are we happy? As prisons, this number is too high for us to have proper rehabilitation of the inmates. Ideally, we're supposed to have 1 staff to 3 prisoners. But now we are having 1 staff to around 7 or 8 prisoners. How do you rehabilitate these people? That's why, although we have reduced recidivism rate, but with this number, we can't afford. So my point here is legal aid, probably if we get a lot of support, the number of remands could easily go lower and lower such that we have a better rehabilitation. The second comment I want to give on is just also information. I've seen there are so many ladies around. I don't know why. And I presume all these are lawyers. I have your sisters in prisons. I want you to get that statistics. I don't know what you're going to do about it. I have 1,897 female convicts. Then I have 1,789 remand. Then I have 165 judgment debtors. Women also borrow money and refuse to pay. In total, I have 3,851 female inmates. Actually, they form 4.9%. Please take a lot of interest in these ladies. Even those who are charged with capital offenses, please study the offenses. Those on capital offenses, especially murder, if you follow critically, they arise from sex offenses, they arise from domestic violence, and many others. So I applaud you to have a lot of interest in those cases. Then another one is about judgment debtors. This is where we fail to understand. Basically, I have around 600. This is a whole prison like upper prison, a whole prison of judgment debtors. I don't understand. Somebody has failed to pay you. Now you lock him up. How will this person pay you back? Is there no way good enough? Our law society is here and many stakeholders are here. Can't you do something about this? Why can't this person stay out there and pay your debts other than us keeping him? And we put you in yellow and we feed you. We have no problem. Even the allowance you give to us is not enough to give you what you're supposed to do. Otherwise, I want to thank you so much for inviting us for this. I've really learned a lot. And we shall be open to legal aid, a special LDC. As you know, actually, I am the one who gives permission because I'm the one who is taking custody of the inmates. I don't want dangerous people to meet my prisoners. So I'm the one who gives permission. But as you know, I've never had any problem with LDC or legal aid. I've never had.
Thank you.
The challenge we used to have were those briefcase legal aid.
Yeah.
I don't know if it was accountability. Those were, I was very rigid. But with Makerere, with LDC, I have no problem. Otherwise, thank you so much.
Thank you. Thank you so much, Afand. I've given you a lot of time because you are sharing very important information. But in Makerere, we also appreciate you have been reading your letters of authorization. It's only now that I'm meeting you. Thank you so much for the support, and our students are so much appreciative. So two more people, the colleagues at the back. First, the one behind you. Let's start with her, then if we can finish with the one that was next to you. Let's keep it brief.
Thank you so much. My name is Jemima Elizabeth Chiudu. I am part of the legal department at National Union of Disabled Persons of Uganda. As persons with disabilities, we do appreciate the LDC Legal Aid Clinic because they have been very instrumental in helping persons with disabilities attain justice through the justice system. But also my humble appeal is that the rest of the legal aid service providers do also look at a twin track approach for persons with disabilities, giving disability-centered interventions that is only for persons with disability, but also for disability mainstreaming, because as persons with disabilities, we do face very many challenges that the general community can help us solve while we are trying to attain justice. Thank you so much.
Lastly.
Thank you very much. I am Dr. Olawunmi Okoyemi Obisheson. I'm the head of Department Clinical Legal Education, Kampala International University, and I'm here representing my dean, Dr. Esther Kisubi. I appreciate all the comments and the discussion, and I'll be standing on the existing protocol. I'll be making my comment on 2 points based on personal experience. The first is, for over a year now at Kampala International University, we've been trying to start the legal aid for the university, and the process has been so tedious and not straightforward. And I actually found it strange, because I'm a Nigerian, and back home we have the NULAI, that is the Network of University Legal Aid International, and that is the contemporary of the UNILAC. So when I came and I found out there's UNILAC, I was happy. So I think to reduce the bottlenecks of the involvement of the university students who are actually willing and ready in their numbers to provide this legal aid services, we can just, my recommendation actually is that since the UNILAC has been recognized and registered, all other interested universities can just register with UNILAC. UNILAC is the umbrella. And since that is registered, instead of each university registering as an NGO, registering as an institution, registering as, I think, because you see, even these students, they are not stable. They will graduate, they will go, we keep having new sets. But then, UNILAC remains the same. So I'm proposing that just like we do back in Nigeria, every university that is interested in starting a legal aid clinic registers with the umbrella body, which in this instance is the UNILAC. Also, on the issue of the prison, we've been to the prison. We want to, our students are willing to render services. And then we met another challenge. I don't know, but we were told to go and bring the memorandum of understanding. And I'm like, I believe you should have your terms and conditions to bring us on board. Now, we don't know what you want. How do we go back and start drafting? So I think since this is a voluntary service, the requirements and the process of getting involved should be made simpler and more straightforward. This is a voluntary service. Thank you.
Okay, thank you so much, colleagues. Every single comment, question, I think adds value to the panel. I'm going to invite the panelists, give them 1 minute each, but before I do that, I see some of the questions actually touch on me directly, so I'm abusing my position as moderator and converting myself into a panelist. I want to respond to 3 things quickly. First of all, our colleague from KIU, make sure that Afande Tio does not leave before they authorize you to go to prison. That's what we did, and I know he will. And you raised the question that relates to what Professor Kakoza raised, which I want to respond. When we started in 2012 as the public interest law clinic in Makerere, we were eager to provide legal aid services because we were already doing legal literacy in the community, so we just wanted a certificate from Law Council. It became so hard for us to obtain that certificate because university-based clinics were not known to Law Council. So they didn't know how to deal with us. They were not sure about our legal status. Are you registered? When we produced the University and Tertiary Institutions Act and the letter, but the way we went around it, we actually volunteered to work with the Law Council to come up with a legal framework for university-based law clinics. And we worked for a period of over I think there were 2 to 3 years, including benchmarking, and we came up with regulations, the legal aid university-based law clinic regulations in draft form. We pushed for those regulations. Fortunately, at a certain point, I was privileged to be a member of the Law Council and chair of the Legal Aid Committee. So I really pushed those regulations. And one of the things that we made sure is in those regulations is to make it mandatory for all universities to have university-based law clinics to harness the benefits of the clinical approach. By the time I was dropped from Law Council, I won't share the reasons why. Those regulations were in advanced stages. They were with the Parliamentary Council for the final touch here and there. It's now 3 years. I've been following up. I think we need to follow up. If there's anyone from law council, please, Deborah, I know you are no longer there, but you know about what I'm talking about. Let's join hands and we follow up so that these regulations are promulgated. The secretary is here. Oh, where is he? Stand up and we see you. Just stand up and where is she? There, she's here. Yes, where are our regulations? Please clap for her. Please clap for Madame Naba, because I hadn't seen her. She's hiding behind the flower when I spoke about. Yes, please. Thank you so much, Professor Kakoza. Madam, we need those regulations, and we are going to come and demand for those regulations. Thank you so much, Sylvia, for fishing her out. She's here. Yeah, and that also relates to the KIU concern about UNILAC. So it's already structured, and UNILAC as an umbrella body. UNILAC is the University East African network for university-based law clinics. So we need to push for these regulations. I won't take a lot of time just to comment also on what Afande Tio has said. He didn't mention that actually trends show, and I'm sure Lillian knows, that the number of female prisoners is on the increase. And it's a global issue, which has actually increased quite a lot after COVID. We need to find out what the causes are. Most of the causes are Tio, the women that are not paying debts. For them, they borrow to pay fees. The men that you have borrow to get another wife. So please understand that as you take custody of those women. But clearly, Uganda is in breach of its international obligations, because the International Covenant on Civil and Political Rights is very clear. It proscribes incarceration for civil obligations. And in one of the UPR recommendations, Universal Periodic Review, one of the recommendations was for Uganda to reconsider its law that allows for the incarceration of civil debtors. So something to think about. I'm not saying go and borrow and don't pay. Please, when you borrow, pay. There could be many debtors here. Please, after this meeting, go back and pay your debts. Otherwise, you'll be seeing a funded to you, because the law is still in place. Lillian, I've spoken a lot. 1 minute, if you have anything to respond to.
Thank you very much, Mr. Mbazira. Two things. We are overwhelmed as legal aid service providers. The numbers have more than quadrupled since the funding cuts started. Where does a citizenship go to when we are stranded? To the state. So this national legal aid law, something has to come out of it. I was wondering how we can translate the commitments that the Attorney General made this morning into something tangible for us as legal aid service providers. I want to add that witness protection is also another critical law that needs to pass alongside the national legal aid law. Most times we release victims back into the communities and they are re-victimized because we don't have witness protection and we do not have sufficient state-led shelters. There's an attempt to set up shelters by, I still call them the jealous sector, but it is not sufficient. So that's one other thing that we need to pay attention to. But to conclude by saying that legal aid is an economic driver. In the last 6 months, we have recovered 38 million from Moroto. We have gotten this money from the men in Moroto and put it into the hands of women. That should tell you something. We are also unlocking capital, we are unlocking collateral through the legal aid service provision that we are providing. So it's a development issue that we must pay attention to as a nation. It's not just legal aid, it is something that contributes to development. As Sylvia has said, we have 5 years to report to 2030, the Sustainable Development Goals, and we won't have some tangible results if we do not address the access to justice issue. Thank you very much for having us.
Thank you, Lillian. Your worship.
Thank you so much, moderator. There was nothing in the plenary that came specifically to judiciary, but this is what I want to say concerning legal aid, that more than ever before, at such a time when we are grappling with funding where donors have pulled out in supporting what used to be legal aid, it's a time for the government to be serious It's a time for the legal service aid providers who are here to hold government accountable and push to have a public defender system. I know Justice Centers is there. It's a time to give it attention. It's a time to come up with a paralegal system that died out completely. And you'll find people don't get advice. There was a comment by the president on saying on the quality of state-funded legal representation that it usually comes in late. I think it didn't come as late as it's supposed to be, but already the practice is we shall wait for when the cases are cause listed and then we will go. We need to go beyond that. We need to say that there's somebody advising the accused person from the time they get in contact with the law. That is being a suspect at police. Immediately have some representation, have somebody telling you these are your rights, you have a right to keep silent, you have a right to legal representation, all through the system. And so it's time now, as we celebrate 25 years, to pay more attention to that. We are grappling with pre-trial detention, a very long period. I am sure if we had a robust legal service providers or a public defender system, that number would go down greatly, backlog. Sometimes it's caused by the issues of saying people are not represented. People do not know what to do. People don't know what exactly to say. That also affects. And not everybody who is seated behind that in the bench knows exactly how to treat people, especially when they are not represented. So as we walk out here, let's go committed to say how can we make a change. Thank you.
Thank you, Sylvia. Thank you so much, and for all the contribution and for all the champions that are going out of here converted to make sure that we have a state-funded legal aid. My last parting comments are, legal aid is an important ingredient of access to justice. Let us not be misled by the word aid. When we hear the word aid, then we begin to think it is just a basic need. But it's a right that propels the right to fair hearing that we've had is non-derogable, the right to equality before the law, and access to justice. And therefore, if we have legal aid, it means we empower the community to prevent violations, but also to seek effective legal remedies. When we have legal aid, it is very important that we look at all its ingredients, including community empowerment. And that is why paralegalism becomes very important and at the center. And at this moment, I also want to call upon the Uganda Law Council to get back to the drawing board, because we are having regulation for paralegals that we are being formulated, and up to now, we don't have them. Legal aid provides early legal representation at the earliest entry in the criminal justice system. The question that was asked my brother here, JB, that why do you sanction frivolous charges? Okay, I withdraw it. But yes, would be answered at the earliest entry, where we have paralegals, where we have lawyers, duty counsels, like the Lilonge Declaration. We save a lot of miscarriage of justices. The stories of Justice Madrama that he has given us, which as legal aid service providers come across day by day. The stories of people who have committed to plea bargain and they end up just bargaining for purposes of running away from the prisons, not because they committed a crime. So legal aid would also help us in terms of reducing on the cost of justice. Why? In legal aid, we emphasize alternative dispute resolution. And under the means and merit test, a case has to have 95% chances of succeeding when it goes for litigation. So the lawyers in legal aid service provision concentrate first in mediation, ADR alternatives, and then they take the cases to court when they are so deserving. So we would even reduce the issue of case backlog, and also the fact that a lot of time and costs are invested. And then also I want to conclude by saying that taxpayers, the 80%, they are saying, give us access to justice. Let us invest in legal aid, and let us have equality in the administration of justice. The equation cannot be complete when we only have judicial officers, we have prosecutors, we have prison officers, we have the police, but the lawyers to represent those seeking justice are not sufficient. Okay. I will end it there, and I call upon you all to join the championing for the legal aid law that is going to be comprehensive, that will put in place the Public Defender's Office, or that will put in place a state-funded legal aid structure.
Thank you.
Thank you.
Thank you so much. Sylvia, you didn't have to withdraw the word frivolous. It reminds me one time I went
to... me.
No. I was just
with
the
likely repercussions. I said,
no,
not
at all.
Yes.
I was just reminded of a situation where I went to stand surety for a person charged with being a common nuisance. And the most entertaining bit was the Luganda translation, because they couldn't understand English, where the translator says, "Bakusanze ozuba zuba." Moving around. So this man could not understand how they could say he was moving around aimlessly, like zuba zuba, when he was looking for food for his children. And the most immediate way to secure his release, Mr. Simwe, was to advise him to plead guilty, to get a caution. But that's a story for another day. Mr. Simwe, anything? But please don't defend the frivolousness. We have closed that debate.
Thank you, Chair. Of course, as advised, I will not go there, but from the plenary, there was something about alternative sentence mechanism, which was brought up by the doctor. And as Office of the DPP, we embrace this. Not all the cases that we prosecute that everybody should really go to prison and be locked up. There are mechanisms which somebody can be sentenced, rehabilitated, or reformed. And this is something really we embrace, and we've been practicing it. As for legal aid, as I said when I was making my submissions, issue of access to justice is at the core of any society or any development if a country is to develop. So as we talk about economic development, we need to be mindful of the security and justice in our societies. If we don't have peace, if people are not getting justice, then you will not talk about economic development. This is something that we should all embrace, and we as justice practitioners, we need to do our part and ensure that people get justice and we practice justice. Thank you.
Thank you. Carol?
Very much. I think my closing remarks will be on two things. In 2005, I was working with FIDA, and we went before the Constitutional Review Commission, and we brought out the issue of legal aid, because we had benchmarked with Britain, and of course those are colonial masters. But in Britain, 2% of the GDP of that nation is given to legal aid. At least let's give 1% to legal aid as learning from our colonial masters. The other issue is reminding ourselves, even if you are an individual or an institution, please have about 3 streams of getting funds. And I'll still get back. Our country is an agriculture country. We now have minerals, we have oil and gas. We need to get into that sector, because in January I went to Ntungam to train farmers, associates, and those who have their factories. And I remember when they're the ones who were training me, even if I was training them about governance and advocacy. And at the end of the day, when I told them, they said, "You have taught us so well about your policies, about what, but the problem with you land people, you're very poor." So I said, they said, "You speak a lot of English, but you're very poor." Of course, they had paid me 6 million shillings. I had paid my taxes. So the chairman told me, I have just released to my farmers 1 billion shillings. But remember me, they gave me 6 million, then I had to pay the taxes, and actually, that's when I realized that when people are talking about coffee, we are outside that economy. We speak a lot of English, but we are not a part of the economy. In here, when I met the coffee farmers here, they don't know. They told me, don't speak English here, speak Ruganda. So I had to get Milo, packaged it in Ruganda. But when I asked, I remember one of the trainers we were with, he asked one gentleman who is into the coffee sector, he said, what is your turnover? He said, within 5 years, my turnover was 500 billion. I said, actually, we are very poor. I submit.
Thank you. Thank you so much, colleagues. Lastly, my Vice President, any parting shots? You can do what you did earlier without my permission. You now have my permission to come to the podium. I had forgotten my Vice President. You had my permission, actually.
Thank you very much, Professor, once again, and the panelists. The conversation alone from the plenary is very interesting. And from it, I pick one thing, that everyone actually understands where the problem is, everyone here. And again, from what I see, it seems a lot has been done, but most of it has been talking. People have talked, we've had papers written, we've had research, we've had benchmarking. And as I give my parting shots, really, I think this is time for action. And we should use this opportunity to, move in the right direction. And what should we do? These are my, what I think, and I pick from the room. As Uganda, for us to strengthen access to justice, Uganda must, first of all, this is common, we must fast track the passage of the legal aid bill. And there are other bills which are important that touch this, the Human Rights Defenders Bill, Witness Protection Bill, I had someone talk about it. Then we also must fully implement the pro bono regulations with monitoring and funding support. I also don't want to pick out on the Secretary, Law Council. We've had an issue with the pro bono regulations, where most of our members feel it's forced labor. They're actually not in support of the pro bono regulations, but once we have the law in place, at least every advocate is able to, will be mandated to offer at least 40 hours or represent a client within a period of a year as a prerequisite for their practicing certificate to be renewed. Maybe we can also begin from there. I know it's not popular amongst my electorate. Those who are here, please do not take it against me. I mean the members. But that's really for the better of the general community. We also need to strengthen the independence of the judiciary and the legal profession. This has been our cry as the Radical New Bar, because we believe that an independent judiciary, an independent bar, can do much better in ensuring that access to justice is a reality. And then we also, I'm glad the officer from prison, you talked about the numbers going low. And unfortunately, what happens in prison, every after 1 hour they're counting and the numbers keep dwindling. But we feel we still have a lot to do. We need to address this issue of prison congestion through legal reform and investment in non-custodial measures. And as I conclude, really, ultimately, access to justice is not a privilege of a few. It's a right guaranteed to every Ugandan. And it's the duty of some of us who are in this room, who have an opportunity to speak, who have an opportunity to reach places the common person cannot reach, to ensure that that is realized. Making justice available, affordable, and effective for every Ugandan remains the measure of our nation's commitment to the rule of law and good governance. And that's what we should all focus on. Thank you once again.
Okay, thank you so much. Thank you so much to the panelists. Thank you so much to the organizers. I'll leave it at that. As my panelists leave the stage, please give them a loud hand clap in appreciation. Thank you.
Please join me in once again thanking our panel and also thanking our moderator, Professor Mbazira. Thank you very much for taking us through that session. He didn't see my hand, but it wasn't up, but I had thoughts as well. And since now I have the microphone, I'll just throw in a few. One, just for information, I think a lot of the issues that have been raised concerning the paralegal services and the clinics, these were issues that had been captured in the draft legal aid policy to give them formal recognition. And it's my hope that taking the advice of the Attorney General, we can work together to move some of those processes forward. Also, I recall a few years back, the Uganda Law Reform Commission did extensive work on the issue of civil debts and civil debtors and made some recommendations, and hopefully we can also pick up some of those issues and move them forward. As we conclude that panel discussion, discussing a lot of issues around legal aid, but also around the legal aid clinic, we now come to important part of our proceedings today when we get to hear from our chief guest. I would like to take this honor to humbly invite the chief guest, accompanied by Justices Madrama and Justice Eva Luswata, to come and join us at the podium as we take on the next assignment. My lords, you're welcome. And it is my humble duty now to invite His Lordship, the Honorable Justice Christopher Madrama, to come and invite our chief guest to address the audience. My Lord.
Thank you very much. I know we are all very engaged and tapering towards tiredness, but nonetheless, let's have our main event on this Silver Jubilee celebrations. And it is my singular honor as chairperson of the Management Committee of the Law Development Centre and as one of the pioneers of the Legal Aid Clinic to invite Your Lordship in your capacity as the Chief Justice to come and address your people. Thank you.
My Lord, Justice Christopher Madrama, Chairperson of the Management Committee of the Law Development Centre, Honorable Judges and Justices present, the Honorable Lady Justice Eva Luswata, Chairperson of the Legal Aid Clinic Advisory Board, the Director of LDC, Ms. Lydia Namuli, the Head of the Clinic, representatives of the DPP and other justice actors present, distinguished members of the bar and legal aid service providers, distinguished ladies and gentlemen, good afternoon. Good afternoon. I have the honor this afternoon to stand here in the shoes of the Honorable, the Chief Justice of the Republic of Uganda, who unfortunately was not able to make it for this occasion. He sent me with a written speech, which I will proceed to read verbatim. But before I do so, allow me, in my own capacity, to congratulate and to celebrate the Legal Aid Clinic of the Law Development Centre on achieving this milestone. Listening to the speeches early this morning and the figures of the numbers of people that have been impacted by the clinic over the years, one can only imagine the ripple effects in terms of peace, in terms of justice for the indigent and for the accused persons. The numbers are big, they speak for themselves, and I congratulate you heartily on what you have done. The principle of equality of arms is a tenet of fair trials. And when we think about it deeply, we ask ourselves, how often is it that parties that appear before the courts having either civil or criminal disputes are one party is unfairly disadvantaged as against the other party? And the disadvantages are many, and one of it is poverty, gender dynamics, discrimination. But all these are vulnerabilities which make it very difficult for them to navigate the legal plane. And legal aid service providers play a critical role in creating a balance for this category of our citizenry, who are the majority. And so you can imagine what it is like for a widow, for one who has no idea of the criminal or civil justice system, considering its adversarial nature, to find themselves having to go through the courts. I want to therefore celebrate every legal aid service provider that's present in the room. The work you do is honorable, and I believe a very fulfilling and rewarding one. I now move to the remarks of the Honorable the Chief Justice, and I read them verbatim as I said. It is with profound gratitude and honor that I officiate as guest of honor at the celebration of 25 years of the Legal Aid Clinic of the Law Development Centre. Established in 1998 and commencing operations in 1999, the clinic has for a quarter century linked service to learning and brought access to justice closer to the people. At that time, I was a few years into practice, and I can say candidly that I missed the benefit of this unique innovation in legal training and service to the poor and marginalized. The value that the Legal Aid Clinic adds, both to the bar's formation and to the justice system's effectiveness, is unmistakable. I note the clinic's distinct mandate to provide legal aid to indigent and accused persons. This work complements the judiciary's adjudicatory role. Translated into practical outcomes, it means timely bail hearings, decongestion of prisons, reduced case backlog. And uniquely, the clinic sits within the Law Development Centre, which is the national training space for upcoming advocates, therefore creating fertile ground where skills development and access to justice reinforce each other, a quality urgently needed in our contemporary legal practice. I join everyone gathered here in congratulating the Law Development Centre on this visionary and useful innovation, one that delivers access to justice while building student skills through the globally recognized clinic called Legal Education Program. That program embodies the idea that a lawyer's education should be practical, should be ethical, but above all, people-centered. The relationship between the judiciary and the Law Development Centre demonstrates how collaboration among government institutions can meaningfully improve service delivery for the people of Uganda. From LDC's inception to date, the judiciary has supported the center's growth in law reporting, skills development, and the expansion of legal aid services. On the recommendation of the Legal Aid Clinic Advisory Board, the judiciary endorsed the establishment of a learning court at LDC, a step that was realized through the opening of the LDC court to enhance both learning and service. And this was an innovation which was unprecedented in East Africa. Our shared journey is further reflected in the Judicature Reconciliation Rules of 2011, which recognize the bar course in turn as a reconciliator. I thank the Legal Aid Clinic for operationalizing the framework by posting 17 court-annexed reconciliators across various courts, many of whom now also serve as mediators in the magistrates' courts. The partnership has equally strengthened student practice under the Advocates' Student Practice Regulations of 2004. We have witnessed tangible skills development among bar course students and the clearance of case backlog, particularly through clerkship postings in hard-to-reach areas, enabling accused persons and other litigants to access timely justice. The court-annexed reconciliators are hosted within the judiciary, and the 8 clinics of LAC in Kampala, Mbarara, Lira, Mbale, Kabarole, Masindi, Adjumani, and Jinja. And these now serve more than 10 High Court divisions and circuits. We therefore appreciate the Legal Aid Clinic's community presence, which is preventative as well as curative, pacifying would-be offenders through information, early intervention, and a referral system. We also thank LDC for extending legal and social services to juvenile offenders through the diversion program. From the bench, we see 3 enduring contributions of the Legal Aid Clinic. 1, a service and learning model that works, where supervised student practice expands affordable aid while cultivating the skills, the ethics, and judgment that a strong bar requires. 2, case flow relief and settlement culture, court-annexed reconciliation and mediation, reduce adjournments, and improve party satisfaction. And 3, a reach beyond Kampala, regional and satellite presence, and consistent postings to hard-to-reach districts really do bring services closer to the people. So we celebrate this Silver Jubilee at a time when LDC operates within the Administration of Justice program. And I'm pleased to confirm that the clinic's core interventions and innovations are integrated into the program implementation action plan, whose key outcomes include sustained establishment and strengthening of legal aid clinic services, support to alternative dispute resolution mechanisms, including reconciliation and diversion, and increased access to legal aid as a recognized intermediate outcome within the results framework and aligned to NDP4 indicators. As Chief Justice, I propose 5 priorities to deepen our collective impact. Early access to counsel and fast appearance coverage. Together with the Attorney General, the Office of the DPP, the police, and the bar, we will support duty counsel arrangements and practice SOPs for fast contact and fast appearance, so that no one stands alone at a critical stage due to lack of information or means. Court-annexed ADR at scale. We will expand reconciliation, diversion, and mediation where appropriate. We will protect fair trial rights, and we will ensure predictable scheduling so that ADR complements and does not compete with court time. The judiciary also expects the clinic to maintain tight supervision, clear competency checklists, caseload limits, and file review routines. We will continue to open our courtrooms for learning while safeguarding standards for litigants and students alike. And then an emphasis on data. Access to justice work has to be evidence-led, and we will collaborate on simple shared indicators, time, to first legal contact, representation at first appearance, bail outcomes, diversion and settlement rates that are aligned to NDP and the framework. This data should inform court management, budgeting, and policy. We will also build a system accessible to persons with disabilities, linguistically inclusive, and child-friendly. LAC's diversion program and the training of fit persons and social workers demonstrate how partnerships can protect children while upholding the law. So to the Attorney General and the Law Council, your oversight aligns quality, ethics, and scale across legal aid providers. To the Director and the staff of LDC and the Legal Aid Clinic, you have stewarded public trust and built a reliable pipeline of practice-ready lawyers. To the Uganda Law Society, LASPNet, local governments and development partners, your collaboration turns policy into service. And to our students, this profession is built on competence and character, and you need to keep both. The Legal Aid Clinic has shown that quality and affordability are not opposites. They are the result of deliberate design, good supervision, minimum standards, and a learning culture. Let us extend that design principle across the entire justice chain. At 25, the Legal Aid Clinic is no longer the pilot it was, it is a national asset. Let us carry this model forward within government planning, anchored in the standards and focused on results, so that every Ugandan who needs a lawyer can find one in time, and every young advocate learns by serving. On behalf of the judiciary, I congratulate the Law Development Centre and the Legal Aid Clinic on this Silver Jubilee and pledge our continued partnership in the years ahead. Our commitment is that we pledge to continue providing court platforms for training bar course students and for court annexed services. We commit that through the planning framework, we will support the Legal Aid Clinic's adoption of technology in training and case management so as to increase efficiency. And we will work with partners to institutionalize the shared indicators that strengthen accountability and improve outcomes. Let us remain true to our vision, which is access to justice for all. I thank you. For God and my country,